Welcome, everybody, to the Insurance and Real Estate Committee's public hearing. This is February 11th, 2025. And we are just going to jump right in and get started. Thank you, everyone, for spending your afternoon with us. We really appreciate your time and comments. The first speaker is State Representative Gary Turco.
Madam Chair, I'm also going to testify and with my constituent David Schwartzer, who signed up later on the agenda, if that's okay with you.
That's perfect. Thank you.
Good afternoon, Madam Chair Wood, Vice Chair Barry, Representative Nuccio, and all of the members of the Insurance Committee, rankings and vice chairs that are perhaps on Zoom watching. I'm State Representative Gary Turco, the 27th District for Newington, New Britain. I want to thank this committee very much for raising Senate Bill 1269, an act concerning long-term care. This is a good start. I believe that the bill needs to be more robust and include some additional provisions. I proposed the bill in this committee, House Bill 5280, that I ask you also to consider some of the proposals in that bill for this legislation. But the issue of long-term care premium increases has been a crisis for a number of years now. They're increasing just at a rapid rate, and really believe it's unfair to the consumers, 70,000 individuals who have purchased long-term care throughout our state. So I just wanted to open it up. Thank you so much for taking the time to consider some increased regulations, consumer protections, and improving the industry. And I'd like to turn it over to my constituent, David Schwartzer, who has experienced this firsthand. He's become an expert on the issue to tell you his ideas for what could be in this legislation. Thank you.
Thank you, Representative Turco. Madam Chair and distinguished committee members, my name is David Schwartzer. I'm from Newington, Connecticut, and I'm here today in opposition of SB 1269 as it's currently written. Respectfully, this bill does not bring relief to the 70,000 and perhaps even more Connecticut residents, mostly seniors, who are being forced to choose between buying food, paying their rent or mortgage, or paying for their long-term care insurance. The suggestions in SB 1269 are not new. Some of them were taken almost word for word from SB 1112, introduced in 2023, and SB 406, introduced in 2024. Cutting and pasting the same industry-friendly language year after year does not serve the people. They were ineffective proposals then, and they remain ineffective proposals today. SB 1269 does nothing to hold the industry responsible for their intentional acts, which created this crisis in the first place. Rather, it continues to allow the insurance department to grant these punitive rate increases year after year after year. Asking the insurance department to do evaluations, hold public hearings, and write reports does not bring relief to the policyholders. Your suggestions to warn the applicant has been done in the past, but these warnings were lies. The insurer's explanations of why these increases are needed are lies. And the options offered to help policyholders lower their premiums are lies. It's been said that every lie we tell incurs a debt to the truth, and sooner or later, that debt must be paid. It's the policyholders of Connecticut that are paying the debt incurred by the industry. Instead of SB 1269, I ask you to reconsider HB 5280, introduced by Representatives Turco and D'Amico, and HB 5328 by Representative Blumenthal. Together, these bills are perhaps the most substantive piece of legislation introduced in years. Admittedly, these bills are not friendly to the long-term care insurance industry, but you are not here to make friends. You're not here to get reports that justify the insurance departments continuing to bow to the whims of the industry that created a situation that robbed residents of the protection when they need it most. You are here to create laws that serve the people of Connecticut. Solving this problem is not easy. It takes courage to write new laws that will serve the citizens of Connecticut and not the insurance industry. Does this committee have the courage to do that? I believe you do, and I believe bills 5280 and 5328 provide the roadmap to get it done this year. Thank you, and I would be happy to answer any questions you might have.
Thank you very much for coming today. Do we have any questions? Senator Lesser?
Yes, thank you, Madam Chair. Thank you, Representative Turco and David. It's good to see you again. I think we all heard the passion that you bring to this issue, and I can tell you I share your frustration. These were, from my mind, a faulty product, defective product that have been brought to the market and with a worthy goal, but have not met the need, and a lot of consumers are in a really impossible situation right now. Sort of focusing on what we can do and what we can't do. I'm interested in hearing more about what you think we should be doing. And specifically, in the bill that you referenced that was introduced by Representative D'Amico and Representative Turco, I think you mentioned that there's a buyback provision. How would that work? How have other states implemented something like that, or individual companies offering that? I'm just, at a time when a lot of these companies are standalone, they do not have other books of business. I'm just wondering how that would work procedurally without jeopardizing their ability to stay solvent.
Thank you for that question, Senator. Let me start off by saying that policy buybacks is not unique in the insurance industry. Companies have been doing it for years. It's mostly prevalent in the property casualty industry, where insurers and policyholders have a divergence of what they thought the policy would cover. And it is not unusual for an insurance carrier to offer a buyback of the policy in order to relieve themselves of what would be catastrophic liabilities. It's also not without precedent in long-term care insurance. Transamerica, for example, is on record as offering policy buybacks to some of their customers. What's interesting is they are offering less than the paid premiums to their male policyholders, and they are offering multiple times the paid premium to female policyholders. I spoke to one couple. They paid about $35,000 each over the years for their Transamerica long-term care policy. They offered nothing to the husband, and they offered about $75,000 to the wife. When the husband questioned Transamerica of why they weren't both being offered the same amount, the answer from Transamerica was, well, statistics are showing that women live longer than men and may need to go on claim more often than men. So we're trying to pay back or buy back the policies from women, and we don't really have any interest in buying them back from the male policyholders. A policy buyback is actually very simple. The insurance company offers some sum of money. It's usually nothing less than the premiums that have been paid to date. Most of the times there is some sort of an additional amount that is an incentive to get the policyholder to accept the policy buyback. The policyholder, if a deal can be made, returns the policy to the company. They get their sum of money back, which again is usually more than the premium they paid, and the two parties part ways. The benefit to the insurance company is that for every dollar that they pay in a policy buyback, they are removing sometimes 10 to 20 times that amount of liability from their balance sheet. So based on the escalation in value in long-term care policies over the year, while they may offer $35,000 or $50,000 in return of premium, they are then removing as much as $500,000 or $600,000 or $700,000 of liability. That makes their balance sheet much more robust because they have less liabilities on the books. which invariably raises the value of the stock, which the company can then use to either further incent their CEOs, buy back stock, or do whatever they wish. But it is buying liabilities back for pennies on the dollar when you do a policy buyback.
The general problem, right? I mean, so there are two different issues from my perspective. One is, the initial pricing of these policies and whether or not that was misleading if customers were given false assurance about future rate increases, but that initial, selling the process of the policies. And then that seems separate from what's happening now, which is we've seen year after year of, skyrocketing premiums. As a longtime member of this committee, I've been struggling with this issue for a number of times, but the basic problem that policymakers are wrestling with is if the costs of providing the promised benefit exceed the premiums coming in, you don't want to risk policyholders by threatening a company with insolvency. So how would you sort of think about that? And are there options that additional options that we should consider that would, address the skyrocketing premiums, but would not endanger the financial viability of these companies?
Senator, it's important to keep in mind that if you look at the overall breakdown of types of business within a life insurance company or a financial services company, long-term care insurance makes up about 2% of their overall business. I think it's important to point out that the shortfalls that exist in premiums today is solely the responsibility of these insurance companies. And I would maintain that this is not an accident, that they knew exactly what they were doing when they started to sell these policies. There was a hearing in 2020, and actually, I'm sorry, it was an informational session in 2020 hosted by Insurance Commissioner Andrew Mays that had Tom McInerney as a guest speaker. And he at that time made a statement that when Genworth, which is still today the largest provider of long-term care insurance in the country, that when they started selling these policies in 1974, they didn't have any claim data. They had no understanding of how these policies were going to pan out in the future. While I think it's irresponsible for a company to offer a policy that they have no idea whether or not it's viable, I think it's also irresponsible that our insurance department allowed them to sell these policies without some assurance that they knew what they were doing. But there's actually 5 steps that the industry took to create the crisis that exists today. Step number 1, make sure that the long-term insurance providers all do the same thing. This is perhaps the most important thing, as it leaves the policyholder with no alternatives. And sure, this may be an antitrust violation, but hey, if we get caught, we'll just threaten to pull our business from the state and the regulators will leave us alone. Step number 2, mislead the applicants with false information. Tell them that we've never raised premiums on these policies in the entire time we've been selling them. Let them think that rate increases are going to be minimal. When I bought my policy in 2004, I was required to fill out a state-required financial application. And in that application, again, it stated that Genworth had been selling these policies since 1974. They've been selling my particular policy since 2002, but they wanted to get my assurance that I still felt I could afford the policy if the premium went up by 20%. And that 20% was not written in, it was formally printed on that application. Today, my premiums are over 300% of what they started at back in 2004. I want to go back also to Tom McInerney's comment at the 2020 information session, because he said they needed 20 years to understand their business. If they started selling these policies in 1974, that means by 1994, they should have had enough information that they could properly price these policies. I bought my policy in 2004, a full 10 years after the 20 years that they said they needed. And clearly, they still didn't get it right. To complicate things, step number 3 is to underprice the initial premiums to incent the buyers to get these policies. If I showed you my policy, it would state on one of the pages that the proper premium for my policy was approximately $3,658 a year. Had they shown me that premium, I may or may not have purchased the policy. That would be my decision. But the premium that they charged me was $1,170 a year, a full 65% less than what their own actuaries said they should charge for that policy. I questioned it at the time. I spent 40 years in the insurance industry. I know how to read a policy. And I asked them, how can you be charging me so little? And the answers I got were, well, you and your wife are both buying a policy. You're both relatively young. You're both in good health. So we think that this is a fair premium. What they didn't tell me is that they were paying massive commissions to their brokers and agents to push these policies on the public. Step number 4, cut off sales to these policies from only a few years after they started to sell them. They disclosed to me when I bought my policy that they started selling this policy in 2002. What they didn't tell me is that they intended to stop selling these policies in 2005. What does that mean? They sold too few policies. In some cases, they sold several hundred. In some cases, they sold several thousand. But these policies, as the committee knows, have inflation guarantees on them. And every year they go up 3% or 5% or whatever the policy conditions are. The policy I bought in 2004 was worth about $240,000. Today it's worth over $500,000. They would have known that when they sold it to me. Their actuaries would have been able to tell them exactly what those policies would be worth down the line. By cutting off the sales of these policies after only a few years, they created their own problem. Within the insurance industry, there's what's known as homogeneous policy groups and heterogeneous policy groups. And very simply, what it means is a homogeneous policy group are all the same type of people. They may all be bad drivers. They may all have DUIs on their driving record. They may live in Florida where they know they're going to get hit by a hurricane. What should have happened is that this should have been a heterogeneous policy group so that the people who bought these policies 20, 30, 40 years ago are now aged and going on claim, and there should have been a continuation of the sale of these policies to younger people so that the premiums of the younger people can support the claims that are being paid today. It is virtually impossible with the limited numbers of policies that they sold to be able to support the financial needs that they would have, regardless of interest rates, investment returns, etc., that they claim they didn't get, and that's why they can't afford these policies today. And step number 5, the final step, isolate the long-term care business into separate companies so that they don't have to reveal the profits that are being made by the parent companies. But don't take my word for it. Let me read to you what Tom McInerney, the CEO of Genworth, said in his 2016 annual report. And this is a quote. In February 2016, we announced that one of our strategic objectives is to separate, then isolate through a series of transactions our long-term care insurance business from other U.S. life insurance businesses. Our goal under the plan is to align all long-term care insurance business under Genworth Life Insurance Company, our Delaware domiciled life insurance company. It's important to remember that our insurance department only looks at the company that owns the long-term care policy. So our insurance department is looking at Genworth Life Insurance Company, which is hemorrhaging cash to pay claims and getting minimal premiums because they intentionally stopped selling these policy forms. And I want to be clear, this is not one company that made a mistake. This is an entire industry that are all doing the same thing. This is antitrust at best. It could be a RICO violation at worst. But somewhere on some date in the past, the insurance industry for long-term care got together, probably in a room not different than this, and made these deals on how they would sell these policies and how they would create their own issues. So while Genworth and all these other companies are crying poverty, remember that the parent organization, Genworth Financial, has a balance sheet that today is holding $122 billion in total assets, and of that, almost $90 billion in liquid assets.
Any
Okay,
other-
thank you. Yeah, no, thank you, Madam Chair. Thank you, David. That was a lot. One last question. I appreciate the committee's time. The Connecticut has the partnership plan for long-term care where we pre-certify certain long-term care policies, and these are plans that are designed to allow residents to access Title 19. I was just curious how do you know anything about the pre-certification process, and are we promising, because a plan has been pre-certified, that there won't be associated increases? What does that pre-certification mean, if you know?
Yeah, thank you. That's a great question. My policy is a partnership policy, and I'm sure the committee knows about partnership policies, but very briefly, a partnership policy basically says that if you have a long-term care policy, the value of the policy equals the amount of your personal assets that you can retain should you need long-term care before you have to go on Medicare. So this was a driving factor in my wife and I making a decision to purchase a long-term care policy. Because what many people forget about is if I go on long-term care and I'm required under the state Medicare laws to depreciate all of our assets before I qualify for Medicare, it leaves my wife with no means to continue her lifestyle. So the partnership policy not only allows her to retain a significant amount of our assets to continue her life normally should I need to go on claim, but it also protects the state of Connecticut. Statistically, people who go on long-term care spend about 2 or 3 years in a long-term care facility. The policy that I purchased gives me enough benefits to support me in long-term care for 2 to 3 years. Without that policy, the state of Connecticut is going to have to foot that bill. So the partnership program not only helps the policyholder, but it helps every resident of Connecticut by saving massive amounts of money that don't have to be paid because these people have the common sense to buy a long-term care policy. The problem is, and again, I think this is intentional on the part of the industry, people are being priced out of these policies. I know of one policy where their premium is 1,700% more than when they first bought their policy in the mid-90s. People cannot afford these policies, and they're being forced to abandon their policy, getting nothing in return from the insurance company because they simply cannot afford it. So they've not only given up their coverage, they've given up the asset protection that's available to them under the partnership program.
Okay. Thank you. Thank you very much. I appreciate your all the work you put into this, and thank you for your thoughts and your thoughtful testimony, and thank you, Representative Turco, as well, and thank you, Madam Chair, for the time.
Any further questions? Thank you. Next up, we have Representative Mike D'Amico.
Thank you, Madam Chair, and thank you to the members of the committee for raising this bill, Senate Bill 1269. So my name is Mike D'Amico, State Representative from Farmington's 21st District. I am here, similar to what my colleague did a few minutes ago. I am here with my constituent. His name is Ken Kohlmeyer, and Ken is very knowledgeable about the issues that have just been discussed by Representative Turco and Mr. Schwartzer. So I think I'm going to cede my time, if that's okay, Madam Chair, over to Mr. Kohlmeyer. So thank you.
Distinguished co-chairs and committee members, I oppose Bill Proposal SB 1269 because it represents a superficial attempt to demonstrate interest for the issues. I don't know how many of you hold long-term care insurance policies, but if you do, you will understand what I am about to say. My wife and I hold the policies that we purchased back in 2004 while we were in our mid-50s. The insurer was Monumental Life Insurance, which was part of today's multi-billion-dollar mega insurance finance corporation named Transamerica Financial. Over the years, we witnessed the physical and mental declines of our loved ones and their inability to perform critical activities required for daily living. This experience provided us with confidence about the decision we had made. During the past 4 years, I have made it my business to find the root causes for what is regularly driving our annual and premium rate increase into double-digit percentage territory. Why did not the insurers or the Connecticut Department of Insurance forewarn us about the impending perfect storm coming ashore when both parties knew full well from early on that the product would eventually free fall into a death spiral because of low interest rates, high product costs, discounted pricing, increased longevity, higher morbidities, and insufficient number of policy abandonments and policy forms closures. This acrimonious but state-approved move of closing off policy forms violated the insurance industry's long embraced law of large numbers. It allowed the insurers to cap and then reduce their liabilities while continually increasing premiums to stave off so-called insolvency. Policyholders must now regularly deal with aggressive and mean-spirited insurer tactics, which feature incessant and predatory rate increases being their weapon of choice. They have but one objective: to force us fixed income seniors to abandon our policies, future security, and independence for one reason and one reason only: to greedily add profit dollars to their multi-billion-dollar bottom lines. We did nothing to deserve such treatment. By the close of 2027, my wife and I will have invested $113,000 into our policies. Our collective annual premium will have grown from $3,000 to $9,000, a 200% increase, way beyond the 20% figure thrown about during the sales pitch. And that number is lower than it would be because we have already abandoned $330,000 of future benefits. My final thought: if the policies for thousands of current policy-holding seniors go away because of the financial pressures exerted by the insurers with the blessing of the state, please think about the enormous financial impact that will begin to burden future state budgets. And of course, they will lead to increased taxes. The mega financial insurance corporations are once again the winner. I am asking you to demonstrate some compassion and to have the courage to do something that will make a meaningful difference. SB 1269 is not up to the challenge. Thank you very much. And if you have any questions, please fire away.
Thank you, Ken. Thank you, Representative D'Amico. Any questions?
Madam
Sure.
Chair, may I just add
Please.
a couple of really quick comments that
Please.
be respectful of the committee's time. First of all, I hope that the testimony of both Mr. Kohlmeyer and Mr. Schwartzer made an impression on the committee. I suspect that it did. I just wanted to add a couple other things that were referenced earlier. Representative Turco and I put in House Bill 5280, which I think the two gentlemen who testified here would indicate they were in favor of. Representative Blumenthal, House Bill 5328, which I would urge you to give serious consideration to. And I would also point out, because perhaps he's too modest to say it, Mr. Kohlmeyer submitted written testimony that goes into more detail beyond what he just, his oral testimony that he just gave. So I hope you'll go online and take a look at Mr. Kohlmeyer's written testimony. And just one final thing in my mind, I hope you'll look with some scrutiny at this claim of potential insolvency by these insurance companies. As was pointed out a couple times during the testimony, my understanding is that this long-term care insurance business is just a really small fraction. I believe Mr. Schwartzer said it was about 2% of the overall business done by insurance companies. So it calls into question this claim of potential insolvency, since it is such a small portion of the overall company's business. I don't know if Mr. Kohlmeyer wants to say anything about that.
Well, yes, I do. I've been doing a fair amount of research, as I mentioned in my notes here. And every time I look at a premium rate increase and I look at the companies that are asking for it, I go and do research on the internet and look at what is their corporate structure and what are the dollars involved. And typically what I see that there's an underlying insurance company, usually affiliated with life and long-term care, and maybe it has some home insurance and auto. It has a varied book of business, and it usually is a $15, $20 billion company. And as Mike said, statistics I've seen would say that the long-term care life insurance sold is roughly, on average, 2% of the total insurance sales, the products for these companies. Now, these companies, these $15 billion companies, most of them not all of them, most of them are folded up under another conglomerate holding company, financial type of a company that is multiples of what the insurance company is doing. So we're talking really big dollars, and they're making a profit, because if they didn't make a profit, they wouldn't be staying in business. And usually, I know the last couple of years have been a little rough, but basically they're earning money. CEOs, as David mentioned, are paid anywhere from $6 million, and that's probably understated because there's a lot of benefits and perks that go along with that. But it's starts at like 6 and goes up to 22 million dollars a year. So they're not hurting for cash. Now, I want to make one other point here. I call this, the tail is wagging the dog in this case, where you got a little business that's really generating no dollars, but yet they're continuing to milk this particular business to generate revenues for their company's bottom line. They've organized in such a way, maybe, that you cannot clearly tell, and by law, they're probably legal in the way they've done this, would be my guess. But, it's not right, because they've got cash reserves, they've got retained earnings that could be applied to help the individuals. David mentioned closing of forms. I've seen forms policy that have only 50 policyholders in it. And those poor people have been, hit with 70, 100%, 150% increases. And so if they had a $5,000 or $6,000 policy, close to doubled, and that's criminal. So the big guys are continuing to manipulate the states, as well as, we're just chopped liver, we're just chattel, and they don't care. And last point here is that the It's easier because for them, because they've been able through law to get the criteria that is measured to be a very narrow bandwidth. It's a very narrow lens that looks at loss ratio and which are important insurance metrics, but they don't look at the profitability of that overarching insurance company, nor do they look at the profitability of even the company that might overarch that company as to their capability to sustain that particular long-term care insurance business that they have. So when you don't do that, you know, the burden falls upon the policyholders. And the policyholders, they shut down, as David said, they shut down the policy forms. It'd be like taking Social Security and cutting off new, younger people from coming into that program and starving off the people that are already in it. And they would see their payments, their checks being reduced year after year because there's no new money coming in the other end. Is that right? Is that immoral to do something like that? It's legal, or it was legal, got approved by the state of Connecticut. Is it legal though? I mean, is it moral? So those are some of the, I call them trickery and manipulation they've been allowed to manipulate figures, as I understand it, malleable ways of looking at it and anticipating and projecting. You know, when you're talking about people's lives and money, we shouldn't be at the whims of projections and anticipations. You know, it's gone on far too long, and we did nothing. We bought the policies in good faith from insurance companies that have been in business for years and years. And as David mentioned, with the language, I had the same language in my Transamerica policy about the 20% and about the company never has sold these policies for X amount of years and has never raised the rates. And it's just it was a bait and switch as far as I'm concerned. And once we had very little increases from 2004, probably up to about 2018, maybe a total increase of 10%. But Katie barred the door when 219 came and 220, after they had you locked in, the policy rates really started skyrocketing. In 2021, my policy rate was $2,900 a year. My wife's was $2,900 a year also. They sent me a letter that said we are going to increase your rates approved by the state from 2,900 and change, almost 3,000, let's say 3,000. And it's going to go in 2 years. By 2023, it would be going up to $6,000. So the two of us would have a nut to pay of $12,000, going from 3,000 or from about 6,000, doubling. And our Social Security, our fixed income wasn't going up at that rate. You know, it takes a lot of 2.5% to get to that. So it's just totally out of whack. It's totally out of balance. We're just being crushed, and you know, something's got to be done. So thank you for listening. I appreciate it. But that's my story.
Thank you. I did review your testimony, Ken. It was extremely detailed. I really liked that you took parts of the policy that said, you know, the language in there. That was very helpful for us to see. Some of the stories you were sharing, as well as David, about some of the companies offering buyouts to women and not men. I did read a lot that you have been contributing to the Connecticut Mirror. I think you just did an opinion piece there. So we really appreciate all the work that you've been putting in, and your recommendations, as well as David's, will be part of the discussion moving forward.
Great.
Senator Wong.
Thank you, Representative D'Amico and Mr. Kohlmeyer. But also wanted to extend to Representative Turco and Mr. Schwartzer. I really appreciate your passionate advocacy, and you've offered me more than enough reading material, and it's been very insightful. And I would concur with the chair of the committee by offering that your testimony outlining each of the particular sections were insightful. I think this committee, its leadership and members have taken this issue very seriously. We've convened a working group for the last 4 or 5 years, working with all the various shareholders and held informational forums on this issue. So I think this is extremely important to members of this committee, and it's an important issue. And we welcome your input and the legislative proposals offered by many of our colleagues, kind of shedding them together, getting all the shareholders' perspectives, weeding through the facts versus some of the misrepresentation that's been asserted, and get to the facts. Because one undeniable fact is healthcare insurance cost continues to rise in an unsustainable rate. And we've seen long-term care, particularly those that have held it for long-term policies, have seen that increase at an excessively high rate. But nevertheless, this committee has the important role of digesting and absorbing all that as a committee of cognizance to be able to work on this issue. So your input and your insight is not for naught. We will take that into consideration and work collaboratively with all the advocates. It's not just the 2 representatives that presented. So many of our colleagues have heard their constituency raise this issue. I think it's an issue that also, as the ranking member on the Aging Committee, we are raising a concept bill, and I look forward to hearing you and your expertise again, because it's always good to be repeated, so it gets embedded and immersed into our memory. But ultimately, this is an issue of critical importance, but the devil is in the details. And the underlying fact is, particularly in our aging in place ideals and the cost of nursing and aging facilities, those costs have increased at such a unacceptable level. We need to get to the root of the problem in addition to these policy questions. So it is an entire ecosystem question. So again, I just want to thank you all. If there's anything else you want to add to it, but I felt it was important to share with all the people that are watching that this is an issue that this committee has looked to address for many, many years. And it's a financing issue. It's a budgetary issue, in addition to a human consideration issue as well.
I add
Surely, sir.
one more comment. The Medicaid program, I'm familiar with that. I have a disabled brother in a nursing home in Missouri. And I'm kind of learning by, exposure that how that works in a given state. And Connecticut has that same program. It's a federal state partnership. And I believe what I've read about Connecticut is that the federal government picks up about 60% of the cost, the state about 40% for any individual who qualifies for Medicaid. And they will pay up to, I think the figure is about a little under $2,000 a month. Is it a month? Yeah, $2,000 a month. No, it's a day. It's a little under $200,000 a year that they will cover. Now, if it's $200,000 roughly, and the state's picking up 40%, it's $80,000 a year for people who have qualified for Medicaid. And there's ways of putting your assets into trust and so on and so forth. So people that are not wealthy, but they might have some money, but they can find a way to shelter that and go onto the Medicaid program, and the state is going to be picking up that tab. And that's multiply that by the 70,000 or 100,000, whatever the number is. It's not going to be that, but it could be. That's the worst case. It's going to be a lot of money that the state's going to have to start ponying up to cover the aged people in this state. So I say that it's nothing's free.
Nothing is free. Well said. But I also wanted to address that point, because that is a pressing point in our state, is the point of Husky C, which is the Medicaid for our seniors. But unfortunately, Connecticut has not had that threshold limit moved since 1973. So when you talk about setting aside assets and things, it is a little tricky with look backs, but people need to understand that our threshold to qualify for Husky C is $1,600 in asset base. and if we could capture your reaction, it's a reaction that shocks most people, that this state of Connecticut has not had a threshold increase since 1973 for our seniors that do not have the opportunity or the assets or the income to be able to sustain care. So that's another bucket of issues we need to address. Look, make no mistake about it. Connecticut is a great state to live. We've done a decent job in regards to providing for our senior population. We could certainly do better, but these are multiple sets of challenges. So when you talked about the Medicaid issue, the fact that 1,600 is the asset limit for anyone to qualify for care under Husky C and not been moved since 1973. You can see the frustration that doesn't exist with long-term care policy holders, as you and Mr. Schwartzer has done, for many of the people that are seniors in our community and state that needs accessible and needed health care. So for me, it's one of many issues for taking care of our aging community in our state that is essential what we do. On the insurance committee, we're focused on the long-term care insurance issue, and your insights and the advocacy of your fellow representatives are greatly appreciated.
Great.
So thank you very much for your presentation.
Thank you very
Thank you,
much.
Madam Chair.
Thanks for coming today. Next up, we have the Honorable Beverly Street, followed by Liz DuPont Deal.
Good afternoon. I don't know who's remote and who is in person, obviously. Senator Carrera, Representative Wood, Senator Wong, Representative Pavlik D'Amato, and members of the Insurance and Real Property Committee. I am Beverly Strite, the Probate Court Administrator for the state of Connecticut. I think this is the first time I've appeared before this committee, and it's certainly a pleasure. I appreciate the opportunity today to testify in opposition to House Bill 6896, an act concerning the adoption of the Uniform Real Property Transfer on Death Act. The probate court system has opposed this bill on a number of occasions in the past, and we continue to oppose it today for a multitude of reasons. I have submitted written testimony, which I won't repeat. I also note that I agree with the testimony of many of the attorneys and the Town Clerks Association that also has submitted testimony in opposition to this bill. Although I appreciate the intent of the proposed bill is to make transfer of real property to be a seamless and easier process, it actually has the opposite consequence. And to just name a few of those adverse consequences, if passed, would not, in fact, simplify the real property transfers of death. Real property at death. It will, in fact, likely lead to increased litigation amongst family members in the probate courts at great expense. It is not a cost savings measure. It will cause clear and possibly irreconcilable confusion and problems in the chain of title. It will have unintended consequences to a person's entire estate plan, which can encompass prudent tax and other planning goals that could be eliminated by virtue of this process. And it may subject many to undue influence and financial exploitation. AARP reports that $28.3 billion a year is stolen from adults age 60 and older through financial exploitation and undue influence, including the change in beneficial information on assets. 72% of that theft is by a friend, family member, or caregiver. Connecticut law has already tried and proven legal structures with appropriate safeguards to accomplish the desired goals of sound and effective transfer of assets at death, such as owning properly jointly with rights of survivorship, retaining or deeding a life use, placing assets in a living trust, and other prudent estate and comprehensive planning measures to ensure that the totality of someone's assets and their intentions for transfer of assets at death are reflected in their legal documents. I do urge the committee to consider all of the positions that have been presented to you in written testimony and to not pass this bill out of committee. Thank you.
Thank you. Nice to see you. Thanks for coming in front of our committee. So the testimony that I read online could not be more drastically different, those in opposition and those in support. And I was wondering, if we already do this with financial information and vehicles or financial accounts, I guess we can call them. And 33 other states have already done this. Why is your testimony and others? Can you just give us the worst case scenarios that you're talking about? Because when I listen to you and I read your testimony, if that's all I read, I would say there's no way, we're going to pass this, but yet we are already doing it. And we're just trying to bring Connecticut in line with what other states do to make it, easier, less stressful, during times that could be very challenging for people. So just share with us what we're missing.
So I would call to the committee's attention that I think there's incorrect information about the number of states that have in fact passed this bill. It's more like in the range of 19. I believe that there is testimony by Attorney Horowitz and another attorney, I think it's Attorney Karp, that outlines the problems in the states that have passed this bill or similar bills and the problems they have encountered. So one example, and I'll tell you one area of increased litigation in the probate courts is to what's called quiet title, disputes over whether or not a person added an adult child as a co-owner of their bank account, as a joint owner, or for convenience purposes. And that scenario is carried out amongst many other transfer on death, payable on death types of beneficiaries. Without the benefit of the expertise of financial planners and estate attorney practitioners, many people whose main asset is their home don't necessarily appreciate that their last will and testament will not, in fact, control the transfer of their assets if they were to engage in asset like this or have a joint account established with a family member, sometimes for convenience. That is one of the gray areas of challenges that I think will arise here. As I shared with you, the growing multi-billion-dollar industry that is in the area of elder fraud and exploitation and growing targets elders in these types of situations, engages friendships and caregiver relationships, and ultimately result in the change of beneficiaries from children sometimes or to a single child to a caregiver. Again, a growing national crisis, and Connecticut is not immune from that horrific trend. The other aspect, and I call your attention to the Town Clerks Association, who deals firsthand with our land records as well. There's no evidence in the chain of title in the public records when that beneficiary passes away or predeceases. The practical impact would be if I were named as a beneficiary on a real estate and that owner passed away and I didn't even know about it. The issue of insurance, liability, responsibility for the property is a problem. In addition to individuals not necessarily engaging in proper revocation should they change their mind down the road. There's no evidence on the land records for the general public or creditors or anyone else if that transfer passed away, except in the event that there's a related probate estate. I think it's right for increased litigation in the probate courts and Superior Court. It's certainly the reflection of our town land records is a public record to show ownership and chain of title, and that will be rendered unclear where these deeds are on the land records. And those are just some of the examples that I share in my testimony as well as in the other written testimony. It's my recollection from reviewing all of the testimony earlier that there in fact was only one person or one entity in support of the bill, and the vast majority of written testimony, I believe, mirrors mine and the concerns I've expressed.
Thank you very much for that explanation. Any questions? Senator Wong.
Thank you, Judge Trate. One of the things you talked about was the increased risk of financial exploitation. You brought the point up, and I want to reiterate that. Could you give us a couple examples? Because again, going back to the Aging Committee, we talked about elder fraud and exploitations and the manipulation that could occur that's so prevailing in our society now. what does the probate process right now do to minimize that kind of exploitation or fraud that may incur?
So the matters that would come before the probate court is when there are allegations of undue influence, sometimes by a family member, sometimes by a third party. In the context of a last will and testament, for example, when family members are omitted by a will, or a situation where it's a joint asset or a beneficial change, where the parties, the family members typically would bring an action in the probate court to determine that it was an improper transfer of those assets or undue influence in the change in beneficial interest. Unfortunately, litigation in the probate court system is on the rise. It is a reflection of a lot of societal trends, but that is a growing dynamic. In the area of conservatorships, which addresses living vulnerable individuals with challenges in managing their affairs and themselves, a growing problem, and you'll see that in the rise in petitions by elderly protective services, is elders who are isolated or alone and suddenly befriended by someone who then ultimately becomes the owner or beneficial designation under various assets and life insurance policies such as this. And as I indicated, that is a multi-billion-dollar industry in this country. You may be familiar with some legislation that was passed last year regarding financial exploitation of elders, where the banking institutions and financial institutions can place holds when there's a transaction that appears to be the subject of exploitation. But that's, a very limited situation where I think as a state, we're trying to protect and curtail that type of exploitation.
And as you can see, the lure of this bill would kind of preempt some of that oversight and probate review. It's very alluring, right? It creates efficiencies. And I can see the merits of this bill from a standpoint of process, speeding up the process, which is one of the banes of the challenges of probate. But let me also come through that upon passage of this bill, you wouldn't have the guardrails for asset and liability recovery. Would that be correct?
Can you clarify that question?
So the passing of title and assets under this proposal, normally through a probate process, in passing through of any asset, the first point of question is a public notice in regards to liabilities and debts that must be cleared on the descendant's property. This process would actually eliminate that kind of oversight and due process for any outstanding liability, would transfer from one to another without the public notice of liabilities and debt burdens. Would that be fair to say?
That is accurate, including even if the surviving spouse were not on that beneficial designation, and they would be entitled to a statutory share, for example, or have responsibility for the expenses of final illness and burial arrangements. Their ability to recover against real property that had someone else as the beneficiary would be significantly restricted and would have to end up being resolved in a probate court. Thus, in fact, more expensive, not efficient. I think it has the appearance of efficiency, the appearance of expeditious resolution of transfer of assets, but in the long run, I think it will be much more expensive and will drag out the resolution of these disputes far longer than a typical probate estate, which can be settled within 6 to 12 months.
My last question to you is, obviously, as the administrator and so many of our probate judges are just stewards of the community. So bless you all for the great work you do. But if I were to ask you, in one of the advocacies of this bill is streamline efficiency. 33 other states have done this, as we've articulated. What would you say to that from a value of the structure of probate court as we have in the state of Connecticut? Some people could say it's a relic of the past antiquity of our state's history. What would you say to that in the real world application of beyond the value of just the probate handling? Because I've seen so many of our probate judge who are friends and colleagues, formerly of the General Assembly, they do more than that. They do custodianship. They do a whole gamut of it. It is one part of the role that you do. So maybe a couple minute pitch in the value and the importance of the structure of probate court in the state of Connecticut and why it should be so valued.
So to clarify, I believe it's only been passed in approximately 18 to 20 states, not over 30 states. Secondly, for example, if you own your home jointly with rights of survivorship with a spouse or a child, by operation of law at the death of one, the surviving owner is the sole owner. There's no delay in that. The evidence on the land records is reflected by an estate tax lien release, and that can be done by expeditious filing of the appropriate documents in the probate court and the release is issued. The vast majority of states in Connecticut are non-taxable under Connecticut's estate tax structure and under the federal estate tax structure. And those returns are due within 6 months of death. So it is dependent on the family, the fiduciary, and the parties to actually file that paperwork with the probate court. We have engaged expedited and more efficient methods by which all these matters can be adjudicated. One, through our e-filing system. Parties have access to the probate courts and filings and to review their files 24 hours a day, 7 days a week. It has increased the efficiency of the courts as well because they are immediately able to access electronic records and process them accordingly. There's not that paper processing and scanning and record keeping that historically has caused, volumes of papers and delay. I think that we have the technology and the staff and the judges that pay careful attention to moving our matters expeditiously. And we would urge parties to file their paperwork in a timely manner to bring conclusion to those estates.
Thank you for your answers and thank you, Madam Chair.
Thank you.
Representative Barry.
Thank you. Does the state currently allow transfer on death for any property, whether it's motor vehicles or other financial instruments?
So through the Department of Motor Vehicle, you can actually designate a beneficiary on your car registration. The beneficiary designated on that document has 60 days to go to DMV to actually register the vehicle in that beneficiary's name. What we have experienced in the probate court system is that within 30 days of death, an individual family member would come to the probate court with those assets to seek a transfer. And the court will issue the transfer of that motor vehicle. And then 30 days later, the designated beneficiary says, wait, I'm on the registration, not on the title, but the registration. And there's a conflict in who actually owns that motor vehicle. That is just one example of where it can be problematic. I think the general public is not always aware of those deadlines and the consequences of the designation. There are absolutely other assets that can be transferred on death or payable on death. An IRA has designated beneficiaries typically. Life insurance has designated beneficiaries. So it's not unheard of. And it's appropriate in some respects. I think people want to just avoid probate. I appreciate that. But there are already in existence appropriate tools and legal measures to undertake those steps in a prudent way that won't have all of the adverse consequences of this particular bill.
Thank you for your testimony.
Thank you.
Next up, we have Liz DuPont Deal, followed by Diana O'Rourke. Just turn on the button. There you go.
Good afternoon, Chairman Wood, Representative Barry, Representative Belnicki. My name is Liz DuPont Deal, and I am the Associate Director of the Connecticut Citizen Action Group. CCAG is proud of our track record of making Connecticut a more fair and just place. I testified today on behalf of our thousands of members. In discuss regarding HB 6895, an act concerning health benefit review. In discussing mandated health benefits, it is helpful to remember that recent tragic events have caused a public outpouring of anger and despair over the health insurance industry's practices surrounding denials of care. People in Connecticut and around the country are struggling to pay for medical care and are increasingly sharing their experiences of health insurance companies standing between them and their doctors. As one example, a physician in Texas posted a video last month recounting that she was called out of the operating room to answer questions by United Healthcare. She received a threatening letter from United Health for speaking out. ProPublica has documented how these companies use artificial intelligence to deny patient claims by the thousands, and also how Cigna saves millions of dollars having its doctors reject claims without reading them. And there'll be links in my written testimony as I submit. CCAG reports on just some of these profiteering among health insurance companies, which seems to be a theme today. In 2023, we found that just 4 health insurance companies, Cigna, Elevance, Anthem, CVS, and United Health, spent $13.4 billion buying back shares of their own stock. They reported $41 billion in profits and $88 million in CEO compensation. It makes sense to periodically review consumer regulations and mandates, but let's be clear, what insurance companies call mandates are in fact protections for consumers. Insurers are attempting to put forward a false reason for the high cost of healthcare and deflecting the blame for their own behavior. Thank you for your attention today.
Thank you, Liz. Any questions? Thank you for your time. Next up, we have Diana O'Rourke, followed by Jan Kritzman.
Hi, thank you very much. My name is Diana O'Rourke. I'm an attorney here in the state of Connecticut. I am speaking today in opposition to the Bill 6896 regarding the Uniform Real Property Transfer on Death Act. I have heard the testimony given by Judge Street, and I appreciate it very much. I've read the written testimonies that have been submitted on both sides of the argument. And I have some concerns about the bill, the way it's written, concerns about transfers on death in general, but with the way the bill is, my practice has been in real estate law and in estate planning and estate administration. From the perspective of real estate law, there are a couple of concerns that I have that I don't see that are addressed in the bill. Number one is if a person, the bill does allow for the transfer on death deed to become effective upon the sale of the property. So in a scenario I can imagine, the individual who has transferred the property, the transferor, has decided to sell the property, and they are in the process of doing so. After the sales contract has been signed, and while the other party is gathering up the information that they need in order to complete the transfer, maybe they're waiting for the mortgage company to come through, the transferor dies. So the question in my mind is, what would happen in a traditional scenario when one person owns the property, that their estate would pick up where they left off and would be compelled to complete the sale based on the laws of contract. In this scenario, upon the transfer on death, the beneficiary immediately inherits. So is the beneficiary then compelled to complete the contract and sell the home? Are they allowed to break the contract, and what repercussions are there? So if perhaps the solution is to have the transferor revoke the transfer on death prior to their decease, what if in the process of selling the home, the contract falls through from the buyer's perspective? Now we've defeated the transfer on death purpose. It falls back into the transferor's estate, and perhaps who inherits under the will or under the laws of intestacy for the transferor is somebody different than was intended under the transfer on death deed itself. So that's a quandary that I see becoming an issue. My second issue is, what if the transferor and the person who is been given the property have die simultaneously? So into whose estate does the property belong? Does it default to the transferor? Does it default to the transfer on death? The statute's not very clear. With regards to
But your 3 minutes are up. If you could please summarize.
Yes, thank you. My other concern, and just to address State Senator Wong's point, there is a section S, under section 3, section 2, letter S, that does state that the property does become subject to the transferor's creditors for a period of up to 18 months. Had the home gone into the probate court, that creditor period would have been limited to 150 days. So what we've effectively done potentially is encumbered that property for a period of up to a year and a half after an individual has passed away before it can be transferred out safely from the recipient of that. So thank you very much for your time.
Diana, I want to thank you for bringing those points to our attention, and we appreciate you providing feedback. Any
Thank you.
other questions? Next up, we have Jan Kritzman, followed by Judy Mandel.
Good afternoon, Insurance Committee members. My name is Jan Kritzman. I live in Newington. I'm here looking for Elon Musk and the Doge boys. I want them to dismantle the long-term care health insurance industry because it's strangling policyholders with annual premium increases. And as our President Trump always says, and I quote, that have never been seen before, quote. Okay, enough about Washington, D.C. If a reduction in these outrageous premiums is not legislated, policyholders will be forced to drop these policies. If they end up in a nursing home, then here comes Title 19, Medicaid. Thank you, taxpayers, state of Connecticut. Personally, my husband and I have long-term health insurance policies from Transamerica Life. We have endured a 350% increase in our premiums since 2004. This May 1st, our annual premium combined will be more than $6,000. And 2 years from now, $7,000. And then what? This is after I pared down the policy benefits in 2021. I equate Transamerica Life Insurance Company to the essence of brutalist architecture, evoking an atmosphere of hostility, repression, and aggression. Last week, Transamerica made us an offer that we can refuse. It looked good for about a minute until I did the math. They offered me a $71,000 buyout, but my husband only a $23,500 buyout. That's weird. I guess they're prejudiced against men. Well, so much for gender equality. Anyway, that totals about $95,000. Sounds pretty good, right? Not so fast. The best part is, for Transamerica, that is, we'd no longer have long-term health insurance, and Transamerica is off the hook for ever having to pay for our long-term health care. Here's the math. $95,000 is considered over and above our gross income. After state and federal income taxes are paid, it would reduce to around $50,000, which would pay for one of us for about 3.5 months in a nursing home at a cost of about $15,000 a month. That's not to mention how this buyout would affect our Social Security benefits. So what do you think? Should we take the buyout? Maybe we should invest the money in what? Bitcoin? The CEOs of Transamerica Life and all the other companies that sell this bait and switch junk insurance make salaries in the millions, no, the multi-millions. I guess they don't have to worry about paying outrageous premiums for this so-called protection in their senior years. Likely it's part of their benefit packages. A hard and fast read into the deep, dark secrets of long-term care health insurance racket can be found in a 76-page booklet called, quote, Fix Connecticut Long-Term Care Insurance, quote, by David Schwartzer, whom you've already heard from today. Please read this. He'll give you the link. To-do list. Combine the highlights of all the pertinent long-term care bills and vote something substantial out of this committee to help about 100,000 Connecticut seniors out of this damning financial burden. Add to the House Bill 1269 the highlights as follows, the highlights of Representative Turco and D'Amico's House Bill 5280, Refund of all premiums to policyholders if requested. Representative Blumenthal's House Bill 5328, not to exceed a 5% increase and spread that out over 5 years instead of 3 years. Boy, 3 years goes by real quick. Representative Turco and D'Amico's House Bill 5144, which is introduced actually into the Finance Committee. Connecticut income tax deduction for proceeds from a buyout, if you want to take it. Put a cap on rate increases. Denial is not just a river in Egypt. Denial is a good option for outrageous rate increase requests. Legislate a Connecticut income tax credit for long-term care premiums. Allow a Connecticut income tax deduction for long-term care premiums paid. It'll ultimately cost the state less than Medicaid payments. If a policyholder accepts a buyout or return of premiums paid, the proceeds should be tax exempt from Connecticut income tax. Here, and this is the important part. Investigate how the Connecticut Insurance Commission constantly and arbitrarily, it seems, comes up with caving into long-term care health insurance companies' exorbitant rate increase requests. Why? They're going to leave Connecticut? Well, don't let the back door hit them on their way out. Then initiate a state-sponsored payroll tax plan like paid family leave. I pay into it now for 5 years. The odds are 50-50 that any person sitting here today is going to need 50-50 long-term care. Any questions?
I think you really hit a wonderful point that we need to take into consideration on the payouts that are being offered is the income tax. I think you said it would affect your social security benefits.
Yes.
All of that needs to be taken into consideration if we are, a lot of these bills are proposing, making people whole again, and making people whole should not be taxing and affecting benefits and all the other things. So I really appreciate you highlighting those points, and we will include them in the bill going forward.
You can do something about Connecticut state income tax for sure. I think if not in this committee, maybe in the Finance Committee. Federal income tax, that's where we need Elon.
Representative Barry.
Oh,
Yeah.
I'm sorry.
Thank you for being here. Can I just ask, how long have you had these policies?
21 years.
And did you notice the big increase in the last couple years, like other people that testified?
I think it doubled after around 10 years.
Okay.
So now we're at, 2014, 15, it started to double. We initially paid somewhere around $1,000 each in 2024. Okay. We read the part about that, they hadn't increased in the past 10 years and blah, 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 blah. My question is what kind of idiots are the bean counter actuaries that work for example, Transamerican Life, that they couldn't foresee what I call inflation? I mean, I lived through the 1970s. I lived through the past few years of inflation. I just bought eggs for $12 yesterday, just a dozen.
Well, I thank you and I concur with the chair about the suggestions you made.
Yeah.
So thank you.
Okay. 1269, it's not a bad bill. I'm not in favor, but I'm not in favor. It's just incomplete. And I think you can complete it by Turco and D'Amico's 2 bills that they've submitted and Blumenthal's bill. And yeah, you can.
Don't go anywhere. Senator Lesser.
Thank you, Madam Chair. Hi, Jan, how are you?
Not well, normally I'm okay. Today I'm very upset. Go ahead.
So a question for you. I was listening to David earlier about refunding of premiums or buyback provision. Sounds like one of the problems you're getting with a buyback that you got from Transamerica, that offer, is that the money isn't enough. Just out of curiosity, do you know how much you've paid in premiums, you and
Yes.
your husband?
Between the two of us, 70,000.
That's how much you paid in premiums.
Yes, since 2004. In fact, I requested a premium payment history from Transamerica just recently. And they sent it to me. I got it in the mail the other day. Yeah, 35,000 each.
So if you and they're offering, and what's the value of the buyback that you're off? You said it earlier, but what was the amount that you were offered as part of the buyback?
First of all, I'd like to say, okay, if I
Yeah.
took the buyback, I am without long-term care. Me and my husband
Right,
both.
of course.
No long-term care. Okay, what we get after the buyout is bupkies. You know what that means. Okay, now, they offered me 71,000. And they offered my husband 23,500, which is a total of a little under 95,000. So I called up and I talked to a very robotic person that answered the phone at Transamerica. I think I was talking to AI. I had to be talking to AI. Yeah, wasn't funny. And I said to her, why, my husband gets such a little paltry amount for a buyback and I get 70-something thousand. And she tap danced and did a few cartwheels and didn't give me much of an explanation at all. Something about that, you know, women live longer than men. Not in my family, but anyway, okay. If I took the buyout, which is about 95,000, that goes on top of my income, gross income, becomes gross income.
No,
And
yeah,
after taxes, we're talking about maybe I would get about 50,000 after I pay the taxes on that. Okay, about 50,000.
right.
What do I
And I,
What do I,
and I know-
50,000 isn't going to pay for 3.5 months for one of us in a nursing home. Unless maybe I buy Bitcoin and it goes up to $1 million a share. I don't know, whatever. Take a
no,
chance.
I understand. And if you had taken, right, all of your premium dollars and not, instead of buying a long-term care policy, instead you bought S&P 500 index fund, you'd be way ahead. So I understand that,
I'm not
inflation.
counting the years 2008 and 9. I don't think so.
Well, but the rest of it has, and except for, right. So I understand, inflationary issue and the tax policy, but nevertheless, what I heard David asking for earlier was to sort of institute what they're offering in your case, which is to at least give the option to refund the premiums, which it sounds like in your case they are doing. They're actually giving you a little bit more than you've paid in premiums, but of
Oh,
course you
no
lose the
refund,
benefit.
no refund of premium, said the robot. Just the buyout.
No, but the buyout is a refund of the premiums, isn't it? De facto, it's what it is.
No, I think it's two separate things.
Okay, so you would want you're looking for a buyout on top of the. I guess I'm not sure what you're asking for.
No, they don't offer a refund of premiums. In other words, the $70,000. No, they didn't offer to give me back that. They offered to give me 71 and offered him 23.5, which is a total of 95. One way or another, whether I took one or the other, okay, I still have to pay income taxes on it.
I understand. Yeah.
Right? And we wouldn't have long-term health care anymore.
Right. No, I guess where I'm sort of stuck, and I apologize, Madam Chair, for being on this, is I don't, to my mind, whether the insurance company wants to call it a refund or a buyout, from your perspective, from your perspective, it's more or less the same thing because you get more or less what you paid in premiums. In this case, a little bit more. You obviously have the tax issue, but it's effectively serving as a, hey, we're both agreeing that you will not, if you were to execute, I'm not saying you should have to do it, but if you were to choose to accept the buyout, you would just be getting basically your money back without the product that you've been paying money for over the years. So that's why I sort of saw it as essentially a refund. But
Well, they're both income taxable. All right, premiums
Right.
paid, income taxable, and the buyout income taxable. Okay.
well, and then okay. Well, I appreciate it. And it's a lot to think about and a really mess of a product that we are sort of working through.
Thanks for your time, Jan. Next up, we have Judy Mandel, followed by Peter Smith.
Thank you, Madam Co-Chair and committee members. My name is Judy Mandel. I'm from Newington, Connecticut. I'm going to tell you a little story. When I was 49 years old, it became apparent that my parents couldn't live on their own any longer in their condo in Florida. They'd moved there 20 years prior when my dad had a heart attack. and my mom made the family decision to sell the house in New Jersey and move to Florida, as many people did, where they had some friends and it might lengthen my dad's life. Now, at that point, he was 87, my mom was 85. She was insulin dependent, a diabetic in a wheelchair, due to arthritis. But the reason we knew it was time for them to do something else was when my dad started getting lost going to the grocery store. He would leave in the car and be gone for hours, and my mom would panic and call myself and my sister. So my sister and I began to search for an assisted living facility near them with some kind of graduated care that they could afford. To make a long story short, there were very few options for them. My folks didn't have pensions or 401ks or much savings at all. It was a heartbreaking situation, and figuring it out fell to me and my sister. As my husband and I also dealt with this, we began to understand how our own kids might have to deal with us in our declining years. We desperately did not want that for them. That's where long-term care insurance seemed to be the answer. We were visited by a very nice agent who sat at our dining room table and told us that General Electric Capital Assurance Company, which became Genworth, had never raised rates on their policies for long-term care. We could afford it, and reading the fine print that said that it could rise, but not more than 20%, we felt we would always be able to afford it. And the peace of mind for our children would be worth it. Now our rates have risen some 300%, not 20%. We know our insurance company isn't the only one with these misleading and fraudulent practices, taking advantage of people who trusted them and their contracts. The bill before us does not protect us from being priced out of these policies just when we may need them. We need strong regulations reining in the insurance companies who seem to have the last word in all of these proposals thus far. I'm familiar with Bill HB 5280 introduced by Representatives Gary Turco and Mike D'Amico, as well as HB 5328 introduced by Representative Matt Blumenthal, which for some reason have been replaced at this time with this one, which I feel is ineffectual in reducing the rate increases for me in the future, so that I may have to relinquish the insurance and go back on that promise to my kids. Possibly these two bills can be combined into a single all-encompassing bill to bring some real relief while I'm still alive. I truly feel the bill you've proposed here, as it stands, is just hoping we all die before you have done anything substantial, and it's basically looking out for the insurance companies and not us. Thank you.
Thank you,
Any-
Judy. Can you just tell us again, because I didn't hear when you were talking, how much your rates have increased over the lifetime?
Over 300%.
Thank you. Any other questions? Thank you, Judy.
Thanks.
Next up, we have Peter Smith, followed by JP Weisky.
Good afternoon, Madam Chair. Representative Cabrera, Representative Wood, Senator Huang, and Representative Pavlik D'Amato, and members of the Insurance and Real Estate Committee. My name is Peter Smith, and I serve as the city clerk of the town of Milford. I'm testifying today as a member of the Connecticut Town Clerks Association in opposition to HB 6896, an act concerning adoption of the Uniform Property, Real Property Transfer on Death Act. You have written testimony submitted by the association, but I wanted to be here in person to really talk about the fact that the Town Clerks Association represents 169 town and city clerks across our state, and town clerks have been integral in Connecticut's governmental framework since the Fundamental Orders of Connecticut. Our role is further codified in 1650 Code of the General Court, which assigned clerks the responsibility of recording land transactions, births, marriages, deaths, functions that remain critical to our duties today. And that really leads into one of the reasons that we are in opposition, is that land records and people's property is usually the most significant asset that they own and that they control. And so when you start dealing with those issues, you really need to be very cautious in terms of what changes are made, how they're interpreted and incorporated. And one of the things that I've learned in my short time as city clerk is the number of people who come into our office very concerned about fraud in terms of their house, in terms of their property. Many clerks have fraud alert systems set up in their office. Those fraud alert systems work, but they work after the action has been done. And so I just want to stress that you'll hear from a lot of attorneys and a lot of others who specialize in various parts of this transactions, but from the clerk's perspective, the recording of land records is really a fundamental function of our office. And they're relied upon to provide accurate public information regarding property ownership. This proposal has been introduced in previous committees. One of the things that, in my experience, is that these kind of pieces of legislation need a lot of work and a lot of collaborative discussions between all parties involved. To my knowledge, that has not taken place. The challenges and the possibilities of bad outcomes really do outweigh the predictability and security of the ownership of your property. Some of the things that the Clerks Association has identified as significant challenges to the bill is really the lack of beneficiary notification. There's no way to ensure that the intended beneficiaries are informed properly. Confirmation of death, establishing a clear and viable process for recognizing the grantor's passing, and chain of title, preventing ambiguity and ensuring continuing property records. The other issue that may not be as important in the context of the ownership of property, but state conveyance taxes. State conveyance taxes are often identified, and
your 3 minutes are up. If you could please summarize.
thank you. But you have state conveyance taxes, you have the probate's role, you have new owner contact information, and the ability for the tax collector to do their job. I'm saying this, that we're opposed to the bill as written, but we think if you're going to do a project like this, you really need to bring all the folks in and create a collaboration. Thank you.
Thank you for that last comment. I was actually going to ask you, if the bill was improved, would you be supportive of it?
I think that's a question that really has to go to the whole group that would be involved. I heard your comments before in terms of sort of saying we do this transfer on vehicles, we do this transfer on bank accounts. I think everyone would agree that the ownership of their home is the most important asset. I think probate court and Representative Strike-Cafalis has really did a good job of talking about some of the dangers in terms of people being abused and folks being taken advantage of. I'm always one who believes that sitting down and working through things is the best way to get to an end. But I couldn't commit for those other folks.
Okay, I appreciate those. Senator Lesser.
Thank you, Madam Chair. Good to see you, Mr. Smith. I'm not sure when the last time you testified for the legislature was, but it's probably been a minute. Wanted to thank you for your testimony. Just curious if there are other stakeholders that we should be looking to include in that process for conversations about ways to improve this bill and address the issues that you mentioned.
Yeah, I think clearly the probate court, but also the Bar Association. I mean, they're really the experts in terms of the legal side. What I've been impressed with since my time as a city clerk is the amount of understanding and depth of understanding in terms of all the processes that takes place and especially as it pertains to land records. We have some very experienced and knowledgeable folks in the association, and I think you probably don't need more than 3 or 4 or 5, but I think all of those people would really need to collaborate.
Well, thank you. Thank you for your thoughtful testimony. It's good to see you.
Thank you.
Peter, good to see you. Thank you for your testimony. Next up, we have JP Weisky, followed by Eric George.
Thank you. And thank you for taking the time. I am here in support of HB 6895, a bill that works on the state mandated benefits review process. I am JP Weisky. I'm the executive director of the Health Benefits Institute. I would note for experience that it was a longtime author of the KHI Mandates in the States publication, which published annually. and cataloged all the state mandates. I also supervised a similar process for the state of Wisconsin that deals with social financial impacts that are required before any vote on any state mandate in the state of Wisconsin. And to be clear, state mandates come in a number of forms. The most obvious is clearly benefit design and coverage of a service or condition, but there's also significant administrative mandates that limit the ability of insurers to review claims. I understand that this is a controversial issue for a number of folks, but it is an important cost driver for health insurance. In KHI, by the time we finished our reports in 2013, there were 2,270 state mandates nationwide. Connecticut certainly followed that trend. And it's important to note that these mandates only typically apply to the fully insured market, meaning it doesn't apply to the self-funded or ERISA plans. Meanwhile, the Connecticut small group market has shrunk, and the number of insurers operating the fully insured market in Connecticut has also shrunk, mirroring nationwide issues. The problems of the fully insured market are not solely because of the state mandated benefits, but increasing costs because of the benefits never helps. HB 6895 subjects state mandated benefits to a more rigorous process, ensuring the legislature fully understands the cost of a mandate before passing it. We urge you to support HB 8. We urge you to support the bill, and I'm happy to answer any questions. Thank you.
Thank you, JP. One of the reasons why this bill has been submitted is when the Affordable Care Act went into place, the language in statute basically says any additional benefits above the essential health benefits that cost would be borne by the state. And we're just concerned with this new administration, if something like that should pass. Has anything like this passed? Is there talk of this passing at the federal level? Can you kind of give us an overview at the high level of what we can expect going forward?
Sure. Like most issues with the Affordable Care Act, there has certainly been a ping-ponging of issues back and forth between the Obama administration to the Trump administration to the Biden administration, now back to the Trump administration. I would say that the rules around the coverage of whether or not states have to pick up those costs have been fluid and have been unclear. We certainly did see from 2010 on a limited number of mandates across the country. There was very little expansion from 2010 until later in the Biden administration, where there was more movement. I think if you have a concern, I think it's well founded. I suspect that this is going to be an issue with the Trump administration. The rules process that allowed flexibility can similarly be changed by the Trump administration. I believe they do it in the Notice of Benefit Payment Parameters, which is an annual rule. So I would expect that the Trump administration, when we move into next year, would see some sort of changes there, irregardless of whether Congress acts or not. So I think it's a valid concern, and certainly with the focus on benefits and federal costs, that may be a piece that is of interest to this administration.
And who at the federal level would implement the review on the benefits? Is it CMS? Is it done through our Department of Insurance? Is it done with each individual state carriers? Like, how would that process be initiated? And I'm just asking because, planning administratively, if something like that was to move forward, I'd like to understand the process.
Yeah, I think that's a great question. I don't know that there's been much movement there in understanding how that would actually be implemented. I don't know that states have been consistently, looked at on this. I would suspect that it would move to CCIO, would be in charge of this, and they'd be looking at this from the standpoint of the cost of the underlying claims. And sort of trying to add that up. The way the language sort of works, there's a variety of methodologies that they could use to sort of collect the money back from the states on this, either through different exchange fees or other pieces back through a number of entities. So I think there's options for them. But I think where it will go is an open question, how it's actually implemented. I think certainly, your Office of Commissioner of Insurance would have an involvement there in negotiating over, the actual piece. There is some piece there certainly for your department, which is, filled with experts. But I think that's an area that's going to be an open question.
Thank you, Representative Barry.
Thank you. Thank you, JP, for your testimony.
Thank you.
How many states have enacted a mandate review?
I believe again, it's important to understand that, what they mean is very different. I believe there are, I had these numbers in my head and I lost them, but I believe there's 39 states that have some form of mandate review. They vary from, very simple mandate review processes where you're trying to estimate the cost to, a little bit more elaborate. Like I talked about in my testimony in Wisconsin, there's actually a requirement that you issue a social and financial impact report on every single bill before it gets voted on in committee. There are exceptions to that process, but it's expected to be done in advance of the floor. The advantage of the process that's here, which is a little bit more robust, is since the KHI report has gone away, there's not a lot of studying of individual mandates, and hiring actuaries to figure out the cost can take some time. So the advantage of this process is it does give you a much more accurate assessment rather than where it goes. I would also note that there's some variance. The way KHI used to, if you take a look, there's in my written testimony, there's a link to the 2009 report, which I think is the only one left online. What we did is we had a team of actuaries with a sample plan in a sample market that came up. So we'd have common numbers, because a mandate can have a different impact depending on the specific plan that you've got. So for example, if you have a $10,000 deductible plan, whatever you're mandating, say, costs $5,000, it makes a huge difference depending on how it's mandated. So for example, in that scenario, you may not have a huge increase for the $10,000 deductible plan. You may have a bigger increase for a plan that has very low deductibles. On the flip side, if it requires first dollar coverage, that $10,000 deductible plan, you may find a significant increase. There's also variations when you look at frequency. For example, we reviewed mandates, and if you look at the cost of in vitro fertilization, for example, in rural Arkansas, it's unlikely you're able to find a lot of providers there, where in New York, there's a different issue. There's more providers available. So the cost might be different, depending on, the specific market. So it's important to look at this on a market by market basis.
Thank you. Is there any correlation between mandate reviews and health cost premiums?
There are a lot of variations between premiums and a lot of variations with mandates. I would say that would be, I think you would certainly see that the states that have a mandate review probably tend to have fewer mandates passed on average, although it does not preclude, I should note, it does not preclude the passage of mandates. It just gives you a more accurate assessment of what that mandate actually is. And, when we did the social and financial impact reports, there may be a valid reason to look at one specific mandate or another. For example, if you look, I think there's a second surgical opinion mandate, and I think the numbers indicate that actually reduced premiums across the market. So I think there's less mandates passed. I think there's an impact there, but certainly underlying healthcare costs and other drivers have a big impact too. So I think there's fewer mandates and states have a mandate review, but I wouldn't necessarily give you 100% because there's a difference between, the baseline costs on a state to state basis. It is not I'm not saying this is, I don't think I would ever say that, if you eliminated all state mandates, it would be a panacea to healthcare costs, but it does have an impact on the affordability. And there used to be a CBO number back in the 90s, early 2000s that indicated about 1% increase resulted in 200,000 people losing insurance coverage. I don't think that's true anymore, especially with the subsidies in the ACA market, but certainly it does have an impact.
Thank you.
Thank you.
Thank you, JP.
Thank you.
Next, we have Eric George, followed by Grace Brandewin.
Representative Wood, Representative Barry, members of the Insurance and Real Estate Committee. My name is Eric George, and I'm the president of the Insurance Association of Connecticut, and I'm here to talk about auto insurance. Flex rating specifically. We strongly support the passage of House Bill 6897, which would extend the sunset date for our existing flex rating, dealing with personal lines insurance, which is for the most part auto insurance. This statute was put into place in 2006, and it has been consistently re-upped, if you will. The sunset date has been extended for nearly 20 years. Flex rating allows for quick reaction to market conditions by allowing modest changes, 15% per territory, 6% per the state, within a 12-month period. So you avoid very large, drastic rate increases. And these are still filed with the Department of Insurance, who may disapprove these filings. There's laid out in statute how the department can disapprove of these filings, so there is protection. But this allows for vigorous competition in the marketplace, and I want to talk about the auto insurance marketplace in Connecticut. We're very fortunate to have such a competitive market in the state of Connecticut, and a lot of folks have seen that their auto insurance rates, their premiums, and their home insurance premiums have gone up. And by all accounts, it's like that with all of our commodities, everything that we're purchasing. We have seen inflationary impacts here. We have seen very large, drastic jury awards and what I would call lawsuit abuse. We have seen more in auto insurance, greater technology being put into cars than ever before. And cars are reflecting that in their price. And the repair, not only the construction, the manufacture of the car, but the repair of the vehicles costs more. So flex rating does allow for conditions, as market conditions arise, for the competitors to really seize on those conditions and either in an upward or a downward trajectory within that small margin, that 6% or 15%, to file. And again, the department is there to make sure that it is appropriate. We strongly support this bill. We would love to have the sunset go away. And I am not going to assume that you're going to do it. We would appreciate it if it would, so I don't have to come here and grovel and beg every 2 to 5 years. But if it could be extended beyond the 3 years that's currently in the statute, maybe 5 years, that would be great. And that's pretty much it. I think we have a few more people here. I'm happy to answer any questions, but thought we'd take a little divergence here and talk about auto insurance.
Thank you, Eric. Can you just reiterate on how this is helpful to the consumer?
Sure, because you can avoid the very drastic increases if rates don't change for a significant period of time, and we've seen this in other states. I'm going to pick on California right now. The regulatory system in California is not the way it is in Connecticut. If you do not allow rates to reflect the market, there comes a tipping point where you have what would be a drastic increase, or the potential, as we've seen in California, major auto insurers saying we're no longer going to write new. We want to avoid that. And the very, very, I think, beneficial thing that's in flex rating is it's not the wild, wild west, because the department is still there to disapprove a filing if it is inappropriate. And we're fortunate in Connecticut, again, to have such a competitive marketplace, but that is how it can benefit consumers.
Thank you very much. Any questions? Thank you, Eric. Next up, we have Grace Brandewin, followed by Barbara Taylor.
Good afternoon to the chairs, ranking members, and members of the Insurance Committee. My name is Grace Brangman, and I'm a Public Policy Associate with the Connecticut Business Industry Association. Thank you very much for the opportunity to testify in strong support of House Bill 6895, an act concerning health benefit reviews. If there's any singular message that the committee should be taking away from my testimony this afternoon, it's that health benefit mandates drive up the cost of premiums for businesses, which are then passed onto the employees. Benefit reviews allow lawmakers to consider the impact of health benefit mandates before they are implemented. Now, as many of you on this committee may know, health benefit reviews have been a CBIA priority, and we will continue to promote similar legislation. In 2009, the Health Benefit Review Program was established under the Insurance Department. However, participation in this program is optional, and the last mandate review was completed in 2014. HB 6895 amends this program by doing three things. One, it allows the Insurance Committee to review each mandated health benefit that received a public hearing no later than the JF deadline. Two, at the discretion of at least one chair and one ranking member, the committee can submit a list of mandated health benefits to receive a cost-benefit analysis by the Insurance Department. And three, the Insurance Committee can then hold an informational hearing that allows members of the public to ask the Insurance Commissioner and the Commissioner of Health Strategy questions about their cost-benefit report. We find that this process promotes transparency and stakeholder input when mandates are under consideration. Furthermore, CBIA encourages requiring a health benefit analysis for every health mandate bill, similar to what was done in Massachusetts. Currently, HB 6895 does not have that requirement. As it stands, the language reads that the committee can review each mandate. However, it's up to committee leadership to request a cost-benefit analysis. We hope that the committee will consider the Massachusetts framework in further discussions about this bill. Finally, CBIA's Reimagine Connecticut pledge includes finding solutions to provide affordable healthcare for small businesses, and HB 6895 is a meaningful step to achieve those goals. Thank you so much again for the opportunity to testify, and I'm happy to take any questions.
Thank you, Grace. When I first was hearing testimony on this, I was thinking about individuals on, Access Health and stuff. So I really appreciate you bringing the small business perspective, because it is one of the most sensitive markets in terms of purchasing health insurance and providing it to their employees. So we appreciate you reminding us of how important that is. Any other questions? Great. Thank you, Grace. Next up, we have Barbara Taylor, followed by Barry Horowitz.
Good afternoon, chairs and members of the committee. I'm Barbara Taylor, and my testimony today is on HB 6896, an act concerning adoption of the Uniform Real Property Transfer on Death Act. I'm a stockholder of the law firm of Reed and Riga in Hartford. I practice exclusively in estate planning and estate settlement and have done so for over 25 years. I am also the vice chair of the Estates and Probate section of the Connecticut Bar Association. And in that position, I chair our legislative committee. I'm, however, testifying in my individual capacity as a trust and estates practitioner and not as a representative of the Estates and Probate section of the bar, largely because the Estates and Probate section of the bar has had insufficient time since the language of this proposed act adopting the Uniform Real Property Transfer on Death Act was released to review it and get a position approved by the Bar Association. This proposal has not been vetted by the Connecticut Bar Association, and in particular, the sections of the Bar Association who are in the best positions to do so, namely the Estates and Probate section and the Real Property section. While I personally do not have an objection to the concept in theory, enactment of this dramatic a change to Connecticut law should be well vetted by the practitioners experienced in this area of the law. Enactments of uniform laws correctly to comply with the laws of a specific state, particularly Connecticut, should be a careful line-by-line review. Our section is in the process of doing this with two other uniform laws right now, and it's a long, arduous process of volunteers. We have enacted uniform laws in Connecticut before, such as the Uniform Trust Code, that have been successful for Connecticut because of the careful attention to the details of every of the practitioners reviewing the proposal. In addition, gaining support and responding to concerns of stakeholders, like the probate court administrator, is key to the success of any enactment of a uniform law here in Connecticut. This has also not happened with respect to this proposal. The proponents of this legislation say it will save time and money for families. That's far from clear. What is clear is that it will not save families 1 penny of statutory probate fees. Statutory probate fees in Connecticut are not based on the assets that actually pass through probate. Connecticut is very unusual in this respect. It is largely all of the decedent's assets with some limited exceptions. Assets that pass through a transfer on death deed will still be subject to probate fees. And unfortunately, this proposal will create a trap for unrepresented families not knowing that they still have to go to probate and they still have to file a Connecticut estate tax return, or there will be a lien on the property for probate fees, and that lien will start accruing interest in 6 months after the decedent's death. Sadly, beneficiaries may have to actually pay more in probate fees with a transfer on death deed than they would have if the real estate had simply passed by will or irrevocable trust. Furthermore, unlike many states that have enacted this legislation, Connecticut probate courts are largely user-friendly and responsive. Many families dealing with probate without attorneys, many families deal with probate without attorneys, and the assistance of probate courts in modest estates typically is a help, not a hindrance.
Your 3 minutes are up. If you could please summarize.
Okay. Basically, in summary, we have a lot of concerns with the legislation. Those of us who've reviewed it, we think that it shouldn't move forward in this legislative session, and that a review by the Connecticut Bar Association, by the Probate Court Administrator's Office and other stakeholders, and approval by those sections should happen first. Thanks. I'm happy to take any questions.
Barbara, thank you for your recommendations, and we will certainly take them into consideration going forward. Appreciate your time.
Sure.
Next up, we have Barry Horowitz, followed by Mark Dillman.
Honorable committee members. My name's Attorney Barry Horowitz. I'm a member of the Connecticut Bar Association's Estate Planning and Probate section, as well as the Elder Law section and Professional Ethics Committee. I'm a founding member of the law firm of Nierenstein, Horowitz and Associates, a firm that does exclusively estate planning law with offices in Glastonbury as well as Westport. I've been practicing in this area now for over 39 years. I'm testifying against the adoption of the Uniform Real Estate Transfer on Death Act, an act that I've been monitoring in the legislature now for, I believe, 8 years. The informal procedure that this act lays out is controversial, as I'm sure you've heard already. It avoids the protection of the probate court without even the formality of a trust agreement or a conveyancing form with normal deed formalities. To date, after 16 years of debate, only 19 states have enacted it. That number is off the Uniform Law website. You've heard some different numbers, but it is 19 states. Connecticut's Legislature Judiciary Committee has considered the bill repeatedly for the last 8 years and has not moved the bill forward. There's a lot of problems with the bill. I'll try to outline them, though it's in my testimony. First of all, it states that these kind of transfers are non-testamentary. They are testamentary under Connecticut law. Capacity under this bill is that required to make a will, which is a lower standard than other forms of conveyancing and lower than is applied to deeds, yet this transfer is by deed and without the protection of will formalities or the probate court system. If 2 or more transferees are on as beneficiaries and one dies, the entire amount transfers to the other transferee without the wishes considered of the transferor. And by the way, that is not what the transferor would normally want. The Act makes these deeds subject to the spousal elective share, even though transfers outside the probate court process under Connecticut law are not subject to the spousal elective share. The pre-printed forms do not even comply with our statute of deeds. The use of pre-printed forms without even deed formalities or attorney involvement makes it far too easy for an aggressive heir, caregiver, or fraudster to pressure an elder to transfer the property upon death to those without the transfer even being witnessed. Claims of undue influence on the part of an heir or a caregiver are already common. Fraud in real estate transactions has been well documented in the media. This act has the potential of making such claims much more common, as has happened in other states, and may just end up being a make-work bill for litigation attorneys. Furthermore, Connecticut already has various procedures in place to accomplish what this act does. We've got life estate deeds, we've got inter vivos trusts, we've got joint tenancy that provide for a real estate transfer without going through the probate process, and they've been well tested. Clients already routinely confuse probate avoidance with protection from nursing home costs.
Your 3 minutes are up if you can please summarize.
Many will execute these deeds with these forms and believe they have nursing home protection without even attorney being present to correct them. The internet is replete with articles bemoaning the enactment of these deeds in other states and the problems they cause. Problems with getting title insurance, problems when clients get divorced, conflicts with any nuptials, incorrect deeds executed by lay people, claims of incompetency and fraud, children of deceased children being unintentionally disinherited. And the act is also already before a judiciary committee. Their input should be garnered as well. For all these reasons, this act should not move forward at this time. The Bar Association sections on elder law, on estate planning, on real estate law, and the family law need to all be consulted and be part of the practice, part of the process. Connecticut Bankers Association, Connecticut Attorneys Title Insurance Company, Consumer Protection, the Attorney General, the town clerks, Judiciary Committee, all should be part of this process before this bill moves forward. Thank you very much.
Thank you, Barry. And thank you for letting us know that this has spent a lot of time in judiciary and there's probably a ton of testimony and stuff there. This was brought to our committee and it's the first time that I have heard public hearing on it. So thank you. We'll definitely go check out all the previous testimony that went through that committee as well.
Thank you, Representative Wood. I'm aware personally of it being in front of judiciary at least 3 times, and I believe it's 4 times, if not more.
Yeah, so it's definitely had its moment. So thank you for that. Representative Barry.
Thank you. Thank you for being here. Can you explain how this bill, if it passed, would lead to elder abuse?
Yes, it's very informal. Attorneys are not even part of the process. It's set up like a do-it-yourself transfer, doing conveyancing without the involvement of an attorney, doing estate planning without the involvement of an attorney. All that has to happen, and it happens all the time now, even without this, it's just going to be so much worse because attorneys are involved now, is that a child who feels the real estate should be theirs, maybe because they took care of the elder for a long time, a caregiver who has now influenced the elder and literally refuses to care for them if they don't get some kind of compensation like the deed, can be pressured. And once the elder is pressured, they can do this kind of deed without an attorney advising them, without an attorney telling them the ramifications of doing it. And then the elder dies, and then everything just happens and the fights begin. You can go through and look online as I did. Thankfully, this is not the first impression that we have of this act. This act has been around for 16 years. Other states have taken the steps of enacting it before we have. And the articles, they're replete all over the internet. In fact, I would say I have not found a single article that really supports this. There's a very good article about, I think that's in, it's a very good article, I think, by the American Land Association, which I would ask you to look at if you're thinking this might be a good idea. I found that article to be particularly helpful. Other lawyers in other states that I know have been bemoaning this. So it is a kind of act that on its surface, I think sounds appealing, which is, hey, we'll just go ahead, we'll avoid trusts, we'll avoid attorneys, we'll just go ahead and let lay people do their own conveyancing. Connecticut has decided against that, going back to the mid-60s, that we don't want attorneys involved in conveyancing. And when you're conveyancing, particularly with the underlying issues of estate planning, it's that much more delicate and sensitive. You're welcome.
Thank you for your time, Mr. Horwitz. Next up, we have Mark Dillman, followed by Brooke Foley.
Good afternoon, co-chairs and committee members. And first and foremost, thank you for this opportunity. My name is Mark Dillman. I am a licensed public insurance adjuster and a current officer for the Connecticut Association of Public Insurance Adjusters, also known as CAPIA. On behalf of our organization, I would like to offer comments regarding raised Senate Bill number 1270, an act concerning public adjusters. Raised Bill number 1270 provides that any public adjuster fee charged to an insured shall be based on the insurer's settlement amount paid on the account of a loss and collected by such public adjusters only after an insurer has paid such settlement proceeds. The bill simply provides a clarification of a long-standing industry practice, not only in Connecticut, but across the country, beneficial to all parties involved. CAPIA fully supports raised bill number 1270, and the Connecticut Department of Insurance has confirmed the clarification proposed in this bill is in line with its historic interpretation of the impacted statute. CAPIA looks forward to discussing this issue with you in more detail if needed, and would appreciate your support for raised bill number 1270. Thank you.
Thank you. And Mr. Dillman, can you just explain for people in this room that in kind of layman's terms about, you know, how public adjusters are paid and what this statute language is doing to fix it?
Absolutely. Public adjusters, by and large, are paid on a commission basis, representing a policyholder in assisting to submit a claim to an insurance company. So an insurance claim is submitted. There's typically a percent that is capped by statute in the state. And unfortunately, there was a case that came down at the end of last year that interpreted the language actually received, which is in the statute currently. That was interpreted to mean effectively money must actually hit the policyholder's account, bank account, in order for the public adjuster to be owed a portion of that, rather than the benefits inured by the services that the public adjuster provided. And the overarching theme here is that if that were the case, folks with mortgages, which is over 61%, or building owners, dwelling owners, whatever that may be, those funds don't often hit their account just due to the intricacies of how insurance claims are actually paid out. So public adjusters would not be able to collect a fee for those folks with mortgages or an encumbered property, and therefore public adjusting services and the choice of consumers to hire representation would not be available simply because we're not able to accept fees. Unfortunately, we're not going to be able to do the work.
Thank you for that clarification. I just wanted to make sure everyone here and at home could hear the explanation. Any questions from the committee? Great. Thank you, Mr. Dillman. Next up, we have Brooke Foley, followed by Jan Graber.
Good afternoon, Representative Wood, Representative Barry, and other distinguished members of the committee. My name is Brooke Foley, and I'm here on behalf of the American Council of Life Insurers, the Insurance Association of Connecticut, and AHIP. I'm joined today by Jill Rickard and Jan Graebner, who is on the Zoom, and also by Melissa Biggs for AHIP. Thank you for the opportunity to comment today in opposition to Senate Bill 1269. This bill proposes significant restrictions on long-term care premium rate increases, requiring public hearings for increases exceeding 10% and capping rate hikes at the most recent annual consumer price index average for certain older policies. While this bill is well-intentioned, it would have serious consequences for both consumers and insurers by undermining the financial stability of long-term care insurance. The Connecticut Insurance Department already provides robust oversight of long-term care insurance. By law, any premium increase must be reviewed and approved by the insurance commissioner, who ensures that increases are actuarially justified. Additionally, for increases of 20% or more, Connecticut law mandates that they be phased in over a period of 3 years, helping policies to manage any sudden financial strain. Insurers must also notify policyholders at least 30 days in advance, giving them an opportunity to adjust their coverage and maintain meaningful coverage at an affordable cost. ACLI, AIC, and AHIP believe these existing regulations strike a fair balance to protect customers from excessive rate hikes while allowing insurers to make necessary adjustments to remain solvent. We recognize there's challenges in the long-term care market, particularly with the substantial premium increases some policyholders have experienced, especially for older policies with lifetime benefits, inflation protection. When long-term care insurance first was introduced, there were over 100 carriers that offered this coverage, and today fewer than 10 companies remain offering this coverage. The reason is because insurers initially had limited data to accurately price these products, and unforeseen factors such as longer life expectancies, medical advancements, and policyholders keeping their policies for much longer than expected have created unanticipated risks. Unlike other lines of insurance, long-term care insurance requires insurance to collect adequate premiums to cover claims that may not even arise for decades. Because premiums are guaranteed renewable, insurers cannot cancel policies due to changes in an individual's risk. However, they must have the ability to adjust rates over time to ensure they can continue to pay claims. Severe restrictions on rate adjustments could threaten the ability of insurers to fulfill their commitments to policyholders and cause even more carriers to be unable to provide this coverage. Senate Bill 1269 would impose arbitrary caps on rate increases, disregarding actuarial soundness. This will prevent insurers from effectively managing risk and could jeopardize the viability of the long-term care insurance market. Additionally, the National Association of Insurance Commissioners Long-Term Care Actuarial Working Group, which is co-chaired by the Connecticut Insurance Department, is actively working on a multi-state long-term care rate review process. Enacting this bill now would be premature given the ongoing national effort to develop a balanced and effective approach. A sustainable long-term care insurance market requires that policies balance consumer protections with actuarial integrity, ensuring that insurers can continue to meet their obligations to policyholders for years to come. And for these reasons, we ask you to reject this bill.
Thank you. I just want to ask some of the questions that some of the people came to testify here earlier had proposed, how this would affect solvency issues with companies that are posting, 15 billion or $20 billion profits.
Thank you, Madam Chair. I'm Jill Rickard with ACLI, and if it would be okay with you, we have Jan Graber online, who is our senior actuary for ACLI.
Jan Graber, as Jill said, senior actuary at ACLI, and it's going to impact different companies, different insurance companies differently. So if it's a company that only sells long-term care, and they don't have other assets to fund deficiencies in the long-term care block, then they're going to be impacted differently than a company that has several lines of business. That said, insurance or products are priced to reflect the risk of that product. And so, to the extent that a company does have other assets that they can rely on in a deficiency, that has to come from somewhere. And so if I have a life insurance policy and some of my reserves now have to go to pay for long-term care, then there's a chance that the future premiums and the reserves for my life insurance policy might not be sufficient.
Can you also explain the reasoning behind the payouts that have been offered? For example, someone had mentioned today that her and her husband had paid a total of $70,000 to date on their policy, but were offered $95,000 as kind of a buyout. There's these buyouts being offered that are higher than what they've, than the premiums paid. Just talk us through how the companies are able to cover that, and if that is a practice that is more common going forward, or people asking for these buyouts.
I can't really speak to that specific situation because I don't have the details of, the product that they have. I know the company, but the amount of cash buyout, it's not a stated formula. And so companies are offering this as an option because right now there's the non-forfeiture benefit that's available with long-term care is you do get a return of premium, but that's not, in order to be a qualified plan, it cannot be a cash return of premium. And so that would run afoul of the IRS rules. But that said, if a person does, a policyholder does cancel their policy or terminate their policy, they do get a return of premium in the form of benefit. So if they've paid $70,000, $100,000 in premium, they have a paid up policy equal to that $100,000 in premium.
Just to follow up on that, the example that was given would have covered 3 months of benefit. So how does that math work?
Well, again, so you have to kind of step back, I think, and look at, I guess the bigger picture. And so, these policies were meant to provide coverage and provide that coverage when they're truly needed. They do not provide a guarantee. So in the unfortunate incident that, a long-term care event occurs, a policyholder could receive well over $1 million in benefits, and that far exceeds the premium that they paid. So these types of policies, again, are not priced as a guarantee. They're priced as a guarantee of coverage, just like if you have homeowners insurance. You have homeowners insurance to provide, coverage if your house is destroyed by a fire. If your house is not destroyed by a fire, you don't get the premiums back, but you did have coverage during that period. And so I think sometimes that is lost on people that, this is asset protection. This was purchased to cover an unexpected event.
Yep. No, I understand that. And I will say that when we were trying to do work on long-term care insurance several years ago, we had agents come in and testify about, the people that we're not hearing from that have used the benefit, and they were very, very rich. And, they're no longer with us because they have passed, but their families were very grateful for the product. But that being said, you say that you didn't have access to data and the benefits were very rich. Why were the groups closed? Like, why is the product not bringing in younger people and still not, keeping the group viable, spreading out that risk and using that pooling? Why is the group small? And then it's just basically people that have had the product for 20 years, that are forced to kind of carry the risk of that payout.
Right.
Why are more people not being brought in so that the product, so you can say, oh, well, we miscalculated, 25 years ago, but we're going to keep on growing the pool. Just what's the decision-making behind closing the group?
Right. And so there's a lot of different reasons that speak kind of indirectly to that. First of all, yes, long-term care insurance premiums have increased significantly over time. And, many do point to insurers having mispriced these policies, but the reality is that the long-term care insurance was priced based on the best available data at the time, and that was often decades ago. So as an actuary, I am required by actuarial standards of practice to price products to reflect anticipated benefits. And so when these products were first priced or first developed 40 years ago, actuaries relied on reasonable assumptions about how long a typical long care event might last. So, for example, 40 years ago, a long-term care claim might have lasted 2 years in a nursing home. And even with conservative planning, insurers might have said, okay, we're going to say that same event in 40 years might last 4 years. However, if you think about, all the medical advancements that have occurred that result in morbidity improvement, mortality improvement, that same long-term care event could now last over 10 years. And so that's a dramatic increase in the exposure that was not foreseeable. So then you have and so insurers have been filing for premium rate increases because instead of an exposure like this, a future exposure like this, now the exposure is like this. And so, that's what guaranteed renewable means. It means that, policies that as long as a policyholder pays a premium, an insurer can't cancel the policy, even if claims far exceed the initial projections. So the guaranteed renewable provision, it does allow premium adjustments if the overall exposures to claims increases. And that's what we've seen over time. So to, tie that back to your question, when some of this experience has taken, these are long-term products. They've taken the experience has taken more than, a health insurance claim to kind of evolve. And so as that experience develops, again, insurers are saying, oh my gosh, my exposure has now increased tenfold. I've got to raise my premiums to account for that. Okay, so that needs to be approved by regulators. And, because, again, we did not anticipate this high of an increase, but because these products are guaranteed renewable, unlike homeowners, if the exposure gets too high, homeowners insurers can cancel those policies. With long-term care, the guaranteed renewable feature means that those stay in place as long as a policyholder pays a premium. So as an insurer, I cannot walk away from that. So as a result, a lot of companies have said, okay, well, I'm not really able to manage my business, my increasing exposure, because I'm faced with, arbitrary caps or denials on rate increases. So I'm just going to stop selling the policies. I'm going to stop selling new policies, because who would enter a market when, you've priced a product as a guaranteed renewable product so that premiums could increase on the entire group, and now you can't. So as a result, Brooke mentioned this, we've seen a big reduction in the number of carriers that are selling this product. So as a result, that's what's happening with the closed blocks, is we have fewer carriers selling, so consumers don't have access. And then another big issue is, and again, this is where I think a better way to address, consumer protection is information. Help policyholders make informed decisions. A lot of times policyholders or average Americans at age 40, when they should be buying this product, when it is going to be less expensive, they're not thinking long-term care. They're thinking, I have kids, I have college coming up, etc. And so a lot of times I've run into people think that long-term care event would be covered under Medicare. But Medicare only covers, a very short period of time And that has to follow a hospitalization. And so it's that awareness of the need. And most people don't understand at age 40 what the potential cost could be at, age 80. And it's just, there's not a lot of information to, so that consumers can make an informed decision.
I listen, the emails that we get from the Department of Insurance regarding rate increases are 300%, 400%, 75%. I mean, this is not sustainable. So I hear what you're saying, but nationally, there's going to be a cap at 80 years old. It's going to be tied to no more increases. I mean, that was something that came out of NAIC. Connecticut already has a cap. Other states are going to move towards a cap. What is the industry doing? Because you have to be doing something, because these caps are going to be coming down the road. I mean, they're almost here and they're starting to be here. And, the long-term care product that we're talking about is not sold anymore for the obvious reasons that we all just said. But term life, whole life, a hybrid with some beneficiary payout upon death are being sold in record numbers, because those are the new, way to, protect your assets and have a guaranteed benefit. Can we convert some, working with the industry, can we convert some of these very rich, currently unaffordable long-term care products into another type of product? Because you heard it here. If you're at a certain age and you want to protect your assets and you don't want to be a burden on your kids, people are not giving up these policies as I think the industry thought they would. They want some sort of protection in place. They're saying no to $100,000, even though they've only paid 70, because then they don't want to be without the product. So is there some forward?
Well, I think there are a couple of things. And, if there are suggestions for alternatives, we are always open to discussing solutions that help keep that coverage viable while still maintaining the fairness to policyholders. But again, thinking about, we're seeing these large increases, 300, even 400% on what we call legacy blocks. So these are the blocks of business that were priced in the 70s, 80s, even early 90s, when we did not know that people with Alzheimer's then in 20, 30 years later might be living for 10 years in a nursing home. And then, thinking about, just like the risk. So, I talked about that exposure increasing. So just, as the risk and the exposure of long-term care have changed over time, so has the financial situation of a lot of policyholders. And so when individuals first purchased their policies, they selected coverage based on anticipated future needs and their financial expectations and longevity risk. However, 40 years later, those circumstances might have shifted, and financial resources or their health status or their personal risk tolerance, it might be different than they originally expected. So at age 80, for example, a policyholder might not need benefit or continue with the 5% compound inflation. And so when a rate increase occurs, it's important to take time to evaluate coverage choices and consult with your financial advisor or your agent. Talk to your insurer about how can I make adjustments in my benefits that will mitigate some or not, or perhaps all of the increase. If I purchased a policy at 45 and I'm sitting at age 85, if I purchased an unlimited benefit and 5% compound inflation, I might be sitting at age 85 with a $12,000 a month benefit for, and the insurance company has to, the potential exposure is, maybe another 10 years. And so I need to look at my own situation, my own personal situation, and say, hey, do I really need my $12,000 a month benefit to continue to increase at 5%? Maybe I knock that down to 2%. Maybe I knock it down and get rid of the inflation protection altogether. Maybe instead of an unlimited benefit period, maybe I should look at maybe a 3, 4, or 5 year benefit period, and that's going to mitigate a lot of the increase, because again, insurance companies have to price or charge premiums that is reflective of that potential risk. And so that's where insurers come in. They are I've heard time and time again from, just outside of my work role, people that have friends that have a long-term care policy for their mother or father, where they've called the insurance company, and the insurance company can walk you through, how can I mitigate some or all of this risk? What is my, do I still need potentially $2 million of coverage? Because that's what some of these older legacy blocks that are getting the big increases. Yes, people have paid in $70,000, $80,000, but the potential exposure could be well over $1 million or $2 million.
Thank you. Do we have any other questions from the committee? So I'm going to take you up on working with the industry on a solution. We'll definitely need to continue this discussion. Thank you.
Awesome.
And Jan was already on, correct? So next up is Kevin Baldwin.
Hello there. I am the president of the Connecticut chapter of the National Association of Insurance and Financial Advisors, and I am very pleased to be here to ask you to consider making a product available after all that I've heard. The products that have been available up through the last 40 years have been a traditional long-term care product. The upshot is that there have been missed actuarial determinations on those products and have created a rapidly increasing cost. However, what we have in place in 40 some odd other states for the last 7, 8, 9, 10 years is an adjustment to that by making annuities available. Annuities are the hybrid which requires almost no underwriting. So when you put a certain amount of money in, whether it's 100, 200,000, 50,000, it will provide up to 3, or in some cases, if you're young enough, 4 times the annuity benefit for the rest of your life. The guarantee is a guarantee. The premium can't change. The guarantee is a guarantee. The money that will be paid out is guaranteed. The upshot is that it'll pay if you are in your home. It'll pay if you're in a nursing home, assisted living, all kinds of opportunities. Now, where does the money come from? It can be with new sales. You can use the money that's sitting in a CD as an emergency backup for your plan. It can be money that's sitting in long-term or in life insurance. It can be money that is a large sum that is sitting in investments that you're going to move over. For existing clients, and this is interesting, I've heard about a lot of these buyouts or cash outs or whatever. You can use that money for the new payment. You can have people who have purchased annuities with an income rider, but now don't need the income rider. They are more interested in long-term care for various reasons. So with answering 4 or 5 medical questions, you can get this type of a product. However, you can't get it in Connecticut. You have to go to other states and be a resident there in order to qualify for the annuity in Connecticut. So
Your 3 minutes are up. If you could please summarize.
certainly, it's being sold by highly rated companies. It takes money from non-qualified sources and moves it into the qualified, and it is extremely minimal in terms of underwriting. With that, I will certainly be happy to take any questions.
Thank you, Kevin. Any questions?
Thank you.
Thank you for joining us. Anyone else would like to speak, please come up and share any testimony. You're welcome to. All we ask is that you state your names for the record.
Good afternoon, Francis Pickering, Executive Director, Western Connecticut Council of Governments. Good afternoon, Chair Wood and members of the Insurance and Real Estate Committee. Thank you for the opportunity to testify in favor of House Bill 6896, which would enact the Uniform Real Property Transfer on Death Act here in Connecticut. Over the past 30 years, there has been a significant rise in ways to transfer personal property at death without requiring probate. Examples include life insurance proceeds, pension plans, securities, bank accounts, and even automobiles. However, while Connecticut residents can easily pass financial assets and motor vehicles outside of probate, no comparable option currently exists for real estate. HB 6896 would fill this gap. To put this in context, in 1989, Missouri was the first state to permit non-probate transfers of real estate. By 2002, 5 states had passed similar laws, prompting the Uniform Law Commission to study the issue. In 2009, the ULC completed and recommended URPTO-DA. Today, 31 states, the District of Columbia and U.S. Virgin Islands, have adopted these transfer on death deeds, and that number is steadily growing. Now, about the number here, there has been some disagreement. 21 states have adopted the URPTO-DA. An additional 10 states and territories adopted laws largely before URPTO-DA went into effect. So it's 31 in total, but 21 have adopted this specific version. There's been no increase in litigation in these states. Not a surprise, URPTO-DA was designed to reduce litigation. And regarding caution, it's been 36 years since TOD was first adopted, 28 years since Connecticut enacted transfer and death for securities. How many more years do we need to be cautious? URPTO-DA is not intended to replace comprehensive estate planning for larger complex estates. However, for smaller estates where a home is a primary asset, a TOD deed is a straightforward and efficient option for estate planners, for families and estate planners to easily employ. I'm going to skip over an example here, but get to some of the points that were raised earlier. URPTO-DA was developed with input from estate planning, real property, title insurance, banking, and senior legal experts. It has strong national support from the American Bar Association, the ABA Commission on Law and Aging, the American College of Real Estate Lawyers, and the American Association of Retired Persons. Regarding supposed irreconcilable problems in the chain of title, URPTO-DA has actually been recommended by the American Land Title Association. Regarding claims of a potential increase in financial exploitation, it's been recommended by AARP, and what I have in front of me right here, which I can distribute to you by email later, is a brief called Elder Real Estate Fraud and Financial Exploitation Prevention. It was put out by the National Consumer Law Center, the National Association of Realtors, the American Land Title Association, the American Association of Retired Persons. Under legislative initiatives, there's a bulleted list saying these are examples of legislative initiatives that can help states combat and limit the prevalence of elder real estate fraud and financial exploitation. Bullet number 3 is enacting the Uniform Law Commission's Real Property Transfer and Death Act, which provides for easier and less costly transfer of property to heirs. In summary, HB 6896 would introduce a simple and effective method to TOD deed to transfer real property at death. It would not limit or replace other estate planning tools. So if a family is uncomfortable using it, they don't have to use it. If they prefer to use an attorney to help them decide which tool to use or to draft a TOD deed, they would be free to do so. What this bill would do is give Connecticut residents an affordable, flexible option, potentially saving them substantial time and expense. In states that have adopted URPTO-DA, legislators report they're often asked, what took you so long and why didn't we have this sooner? So I urge you to give this bill a serious consideration and hopefully move it forward. There have been some concerns raised about notification and other details. The Uniform Law Commission puts out recommendations. They do not have to be copied and pasted verbatim into state law. So obviously there is always a process of adaptation. And if there are concerns about the details, then I think it's an excellent opportunity to involve all of the stakeholders in such a process. Thank you.
Thank you, Francis. I believe I've seen you in the audience, so you've been here for a lot of testimony. This has been in the Judiciary Committee. We just learned for about 3 years, and your testimony was the only testimony in support of it, and there was a lot of opposition against it, especially from the Connecticut Bar. You had just said that the American Bar Association supports it. So what are we missing here? What's the
Well,
the breakdown?
We are the land of steady habits. There's that. And many of these innovations start in other parts of the country. Western states tend to be more innovative when it comes to their laws. New York just adopted this in 2024. So it is trending, it is spreading. We have an unusual situation in Connecticut this was mentioned before, in our probate court system, which the 2015 tax panel said was so out of step with the rest of the country. We have the highest probate fees in the system, and Connecticut's often been called a bad place to die. I don't know why we can't necessarily fix that. We would like to retain our seniors here. They are valued members of our community. But I think most of it is just fear of change, right? But this is not forcing anything on anybody. It's simply saying, here is an additional tool. It's a very simple tool. Most households can't afford estate planning. Most households don't understand how this works. So if on the deed you can write in who the beneficiary is, that's very simple. Are there legal implications to that? Sure, but there are legal implications to everything we do. And keeping it simple makes it much easier for average households to understand.
Senator Wong.
Thank you, Madam Chair. Welcome, Francis. First, I'll begin by thanking you for the good work that you do as the Executive Director of WestCog. You have articulated great arguments and background, and so we're very lucky to have you. In this case, I actually am surprised. I see you here patiently, and I'm glad that the chair afforded people an opportunity to testify. You heard the Chief Administrator of the Probate Judge cite a couple of points I'd like to be able to get your input and clarification on. We cited 30 plus states that have adopted it. I think your testimony articulated that, but she argued that it was only less than 20. Can you explain to me how we're splitting hairs, or what are the legal definition in that regard?
So if you go to, I believe it's uniformlaws.org, they have a map that shows every state that has adopted this. Every state, and it depends whether you count Washington, D.C. and the Virgin Islands as states, right? So we're talking about states and territories. 21 of those have adopted, and you get an exhaustive list there, have adopted the URPTODA with any changes that their state legislatures thought were appropriate. This first bubbled up to the Uniform Law Commission because a number of states were doing it on their own. So you have states between 1989 and 2009 that adopted it on their own and did not necessarily follow the template laid out by the Uniform Law Commission, but do have transfer on the death deeds. So you have a total of 31 states and territories that have adopted it in one form or another.
I appreciate that clarification. Indeed, I think we're talking with very capable and articulate attorneys. I think we're splitting hairs on this. The second point of contention is the protection against at-risk exploitation. We have elder abuse and fraudulent, and some unfortunately occurs within families. The probate court and its adjudication does somehow kind of filter out some of those bad actors and bad behaviors. Without that, what do you say in adopting this, that you don't have that filter process against exploitation or abuse that occurs?
So to create a transfer on death deed, the owner must have the same legal capacity as they would to execute a valid will. They must be of sound mind and free of undue influence. We have seen with wills that there can also be fraud associated with that, right? So a transfer on death deed does not create necessarily any additional risk than we already have. So that would be my primary response to it. Is there a specific, I mean, right now, as I mentioned, ALTA, AARP, NAR, and NCLC are supporting this as a way to combat exploitation of elders. Transfer on deed, death deeds are publicly available, right? So somebody could theoretically create a fraudulent will, could talk somebody who's not of sound mind into amending their will, and there's no public record of that necessarily, right? That will could be put in a safe somewhere and it appears after the person is deceased. With a transfer on death deed, that is publicly recorded with the town clerk's office. So if you have signed up for notifications about modifications to your property deed, you will be notified of that. So there is arguably more transparency associated with this than there is with the conventional process of creating a will.
It is indeed a state of steady habits, and I think what was articulated is our probate judges provide another layer of scrutiny and protection. And I pressed to get some of the points that you made on that. I'll move on. The third is in regards to liabilities and debt clearance. Without that clarification, descendants probate does not go under that review. So what about people that are liabilities and debts? They would not have a recourse to be able to get access to clarify their debts and burdens. So what would you say to that with the TOD, with the immediate transfer? You don't have the public notice. You don't have an opportunity. I think you cited public notice, but we don't have an opportunity for debtors and liabilities to be able to lay claim before the estate is settled.
So since 1997, Connecticut has allowed securities, right? Bank accounts, pensions, life insurance, other financial instruments to be transferred upon death without going through a state, right? And so sometimes those are relatively small IRAs, sometimes they're rather large investments. And to the best of my knowledge, we haven't seen this problem arise with that. And this is essentially modeled on that successful example that we've had in place for 28 years. Under this bill, under the URPTODA, the rights of creditors of the transfer are also protected. So if there is an estate and the estate is insufficient to satisfy all claims, the estate may enforce liability against the beneficiary of any property transferred using a TOD deed. So that is covered under this bill.
Thank you, Francis. I appreciate your input. You've given us some points and counterpoints to consider. I appreciate your work and thank you.
Thank you.
Thank you, Madam Chair.
Thank you. Any further questions? Great. Anyone else would like to come up and speak? Representative Blumenthal.
Good afternoon. Senator Cabrera, Representative Wood, Vice Chairs Berry and Anwar, Ranking Members Huang and Pavlik D'Amato, distinguished members of the Insurance and Real Estate Committee. My name is Matt Blumenthal. I'm State Representative for the 147th District, and I believe this is the first time I've testified on a bill since I was in law school, so I appreciate the committee's indulgence. I'm here to testify on Senate Bill 1269 and any of the other proposals that the committee may take up regarding long-term care insurance. As I'm sure the committee has heard a lot throughout this hearing, and I've watched some of it and seen in publicly reported news. There is a crisis with regard to long-term care insurance and affordability in the state, with thousands of individuals being priced out of their long-term care insurance after having paid into it for decades and now being forced to drop benefits and not being able to take advantage of the benefits they paid into for so long. I wanted to bring to the committee's attention an issue I became aware of recently, and I'll be submitting written testimony on it as well. There is a class action lawsuit in the Northern District of Illinois against a specific long-term care insurance company. I'm not generally in the habit of citing complaints and lawsuits, but this one happens to be accompanied by exhibits that highlight specific slides of presentations that this particular long-term care insurance company gave to its investors, in which they discussed an issue called shock lapse, which is essentially where a rate increase leads customers of a long-term care insurance product to drop the product. And what they seem to be doing in these slides is essentially bragging to their investors that they were, quote, de-risking their long-term care insurance profile. They in particular indicated that their policy count was down by over 40% since 2015. And these documents are readily available on their website. And what this seems to indicate to me, based on the complaints explanation and these exhibits, is that this company in particular appears to have been engaging in a deliberate strategy of using this shock lapse issue to get individuals to drop their policies and thereby solve their risk profile and maybe achieve profitability. Now, I don't mean to imply in any way that any other company was engaging in this kind of behavior, but it gives the committee an idea of the potential for abuse in this scenario. And I just wanted to contribute to other proposals in addition to the bill I propose and the proposals that you're looking at already this session. There's two additional potential regulatory changes I think could be helpful. One is that when a carrier is looking for a significant rate increase, one of the issues that carriers have raised is that not being able to raise their rates would create a solvency risk for the company, but they do this very casually and in a non-regulated environment, is under my understanding. A requirement that they certify that above, if they're not granted a increase above a certain amount, this would create some sort of material solvency risk for their company. The wording I would leave up to you, obviously, and that the rate increases required to prevent insolvency. That some sort of certification like that, I think, would be useful to test the actual assumptions behind those statements. And additionally, when a carrier files for a rate increase, a regulation could require them to notify all potentially impacted policyholders with a readily available link to allow them to provide public comment on the rate increase. I'm not sure what the current status of what the Department of Insurance does in this regard, but they've reported that they often receive no objections to a particular rate increase from the public. And I think it's important for policyholders to have the opportunity to weigh in. And this is obviously important, not only generally as a consumer protection issue, but also because the state of Connecticut has spent significant resources and provided assistance to the industry when it set up the Connecticut Partnership Program. And if people are being knocked off their long-term care insurance and having to subsist on Medicaid, that provides a significant risk to the state. So in any event, I hope I haven't gone over my time, but I appreciate the committee's indulgence in allowing me to testify and highlight these issues and the written testimony that I will submit.
Thank you very much, Representative Blumenthal. We're very happy to see your bill come in and review that language along with additional members' language that we will be incorporating into the committee's bill going forward. And if you can also send us an email on your additional recommendations, we will incorporate that as well. Thank you very much. And we are making this a priority this legislative session.
Thank you very much, Representative Wood.
Senator Wong.
I appreciate the importance you're attaching to this issue and your consideration of these issues.
Thank you, Madam Chair. Welcome, Representative Blumenthal. In reading the bill, I believe your bill is 5328.
Yes, that's correct.
Okay. And some of the proposals you made, just to kind of flesh it out a little bit, premium increases to not exceed the most recent calendar year average in the consumer price indexing. Give me some of your thoughts related to that. That seems to be a kind of unique way of giving some leeway to the needs, but also tying into the realistic increases instead of the excessive needs, because this committee has enacted legislation that require greater transparency when premiums are in excess of 10%, that a public hearing is required. So give me your rationale on tying it to CDL.
So that provision, essentially an intent, would tie rate increases to the rate of CPI inflation. Obviously it's an aggressive and very strict measure, but meant to start a conversation if possible. And so, obviously, I would be in favor of generally of some sort of restriction on rate increases. It wouldn't necessarily need to be tied to CPI inflation. I understand that there are other potential measures that could be used, but that was my suggestion as an opening bid.
Well, I think one of the points in listening, if you've heard some of the actuarial presentation from the insurers, the cost of healthcare, particularly in our senior care, is just beyond what they anticipate. But can you elaborate a little bit more on listening to your constituents, and as you and Representative Turco and Representative D'Amico have articulated, and so many others within our committee, and as you heard the chair encouragingly say, this has been a priority and will continue to be one. But do many of your constituents feel as though they've been sold a different bill of goods and they've held it for 20 plus years, and to be potentially priced out at the time that they need it the most? Is that a sentiment that you've felt over and over? Maybe you can articulate as well as you advocate for your constituents.
Absolutely. It's definitely something I've heard from a number of constituents, vast increases as much as 173% that have forced them, after they've paid into these policies for 20 odd years, to consider, and in some cases actually drop their insurance. And there's kind of a double injustice there. There's the one, which is that they're just being charged a different bill of goods, as you said. It's kind of a bait and switch to be told you're going to be paying one thing, and then 20 years later being told something else, that you suddenly need to pay something else. But then if you lose the benefit of the coverage, then first of all, you have paid into a system for decades that you're suddenly not going to be able to participate anymore. And also you lose the benefit that you bargained for. And so I do think that many of them feel like it's been a bait and switch. And there are some cases, I can't say certainly all of them, where there were representations made to individuals about the stability of premium increases in the future, or what they would be tied to, or other things like that have not ended up being true in the end. They're very frustrated. They feel violated, frankly. And these are people who have tried to do the right thing for themselves and their loved ones, not only to ensure that they get good care, but also that they're not a burden on the state because they were able to afford it at the time. And so there's an injustice to them in being deprived of this benefit. And I think there's an injustice to the state too, which has contributed significant money to setting up these partnership plans, to trying to make the market work. And if individuals are just going to end up back on Medicaid and Connecticut is paying for it, then you got to wonder, where did all those premiums go? What was the point?
Well, it'll be a far stretch to qualify for our senior care on the Medicaid.
That's true.
We brought up the point in regards to the thresholds. I think the key is it's encouraging, and is repeated. The leadership of this committee, members of this committee, have welcomed the engagement and further conversations. It's going to come with a fiscal note to find some solutions. But as the chair, the House chair of this committee has articulated, we welcome all the shareholders to be part of the solution finding. So welcome to the group, and I thank you for that. And these meeting times seem pale compared to the latest GAE meeting, which I believe you guys were up till 3:30 a.m. So we won't hold you much longer than that. Thank you for your time. Thank you, Madam Chair.
Appreciate you all. I will not hold you till 3 a.m. and appreciate the committee's dedication to this issue and indulgence in allowing me to testify. Thank you.
Thank you, Representative Blumenthal.
Thank you, Attorney Brian Carpy, KARPE, speaking on the behalf of an opposition to, excuse me, Raise Bill 6896. Mr. Pickering's testimony, I was here to talk about the other things that the attorneys were mentioning, but he's made me go off to the left turn. Two things. One, I would like to also address the fact that this bill has been bandied about in the judiciary for about 8 years now, not 3 or 4. It's about 8 years and it hasn't gotten traction. But a couple of things Mr. Pickering did mention that the litigation, there's not much litigation. He haven't really looked at California, New York, Georgia, Washington, Texas, Florida, West Virginia, Minnesota, Kansas, Montana, the Eighth Circuit, and others. Got a whole list here of cases and areas where this transfer on death is being litigated and is really causing some issues. One of the things he did mention that struck me is he wants to keep it simple. He wants to help people do their own estate plan, not big estates, but small ones. Small ones whose house isn't worth $300,000 or $400,000 or $500,000 now, $600,000, $800,000. This bill is going to let people who have no really idea of what's going on make decisions about hundreds of thousands of dollars worth of assets, potentially millions of dollars of assets, because this deed is so easy to fill out. He mentioned that that there's safeguards. Well, with a will, yes, there's witnesses, there's a notary, and generally, except for the electronic versions, generally they're done by attorneys and people in the estate planning world who can identify issues involved with competency, undue influence, things like that. But so I really want to address the fact that it's the people, uninformed people, that are going to really suffer for this, because it's keeping it simple, as he said, makes it too simple for people to screw it up. On the bill, it says that on the back, there's going to be read the instructions, see a lawyer. There's admonition saying it's got significant legal ramifications. There's a frequently asked questions part. My experience is people don't read that. And I'm guilty of that, embarrassingly. I've not read the back of my airline ticket, but yet there's legal ramifications. Who reads the terms and conditions when you sign on to a new application on your phone? I don't believe people are going to read the important things and realize they are impacting hundreds of thousands of dollars worth of assets. There's other impacts, such as ability to get mortgages. They may hinder their beneficiaries from getting mortgages because title insurance won't issue title insurance on it. It jeopardizes potential Medicaid eligibility. People aren't going to understand that. Even though we're trying to keep it simple by filling out this really kind of simple deed, there could be unintended consequences, such as unintended disinheritances. So I urge this committee to oppose this, because I think the ramifications to the uninformed regular people are going to be catastrophic. Thank you.
Thank you very much for your time. I feel like we've asked a lot of questions on this topic, and we appreciate you being here. So thank you.
Happy to answer them again.
I know.
Thank you.
Anyone else have any? Come on. Yep.
Esteemed committee members, thank you for having me. My name is John McCann. Before I start, I just wanted to let you know that a former insurance committee member sends his regards. Honorable Joe Crisco wishes you all well. He's enjoying himself, enjoying his retirement, and wishes he could be here. So a little bit about me. I will endeavor not to take up too much of your time. I'm a practicing attorney with an emphasis in elder law. And so I'm working with older folks in addressing their concerns regarding protecting themselves, making things easier for their loved ones, all the things that you think of in terms of elder law. I am very grateful for the attention your committee is providing to this issue, because anything you can do to make things easier for seniors is absolutely to be appreciated. They need all the help they can get. And we've had a debate here about the pros and cons and that, and I'm not gonna necessarily come down one way or the other. My written testimony indicates that my recommendation would be to take a go slow approach to really explore all of the elements of this. You seem to be at the beginning stages of that, and I applaud that and credit that. I did want to share with you just a anecdote, if you will, that might support the idea of looking at all of the elements and all the possible ramifications and considering both sides of the equation when you're considering what can amount to a law that can have profound consequences on everyday individuals. Most of my time is spent assisting folks maintaining their independence in the community. I often help them utilize the Connecticut Healthcare Program with elders. I'll often attend medical assessments with social workers who are also equally passionate about helping seniors maintain their independence in the community. And part of that presentation is, well, Mr. or Mrs. So-and-so, it looks like we can get you some benefits, some resources so you can stay in your home. But just keep in mind that the state may come back someday and be able to present a claim against your estate. And they're very careful to say estate. I happen to know that currently the Department of Social Services only pursues their claims against the probate estate. Okay? It's a very important distinction and one that can mean all the difference in terms of a senior both being able to maintain their independence in the community, get some help that they, surely deserve, save the state some money by not being thrust into a nursing home unnecessarily. And because of the state's approach to collection in estates, they're able to often preserve that home still in their estate with professional guidance. So I would just ask that as you look at this bill, and it came up earlier, the collection aspects of it are key. And I'm not going to say, positive or negative, but for example, if there was a beneficiary and the state had a claim against that decedent due to benefits that they had received, would that claim be limited to the probate estate, or would it extend to making some kind of clawback against that beneficiary? I welcome the attention that you folks are beginning to pay to this and all the other myriad issues that have been brought up today. I'm going to leave it there in case there are, you have any questions for me. But again, I very much appreciate the attention this is getting, because it, if it's done right, maybe it can add another tool in folks' tool belt. But if it can be done wrong, if it's done unskillfully, if you will, it may result in some very substantial unintended consequences. Thank you, folks.
Thank you. It's John, right?
It is.
John, well, put him on the working group. No, thank you so much for your time.
Thank you.
Anyone else? Great. Thanks everyone for coming. We appreciate you spending the afternoon with us. Take care.
Chris.